Hello, everyone.
Good morning.
I am obviously not Judge Harris, but he is on his way. I'm going to get everybody checked in so that as soon as he is here, we can get this rolling. So let me just kind of run down the list. Jordan, can you hear us?
Jordan, don't pretend like you're not there.
Well, Jordan's probably thinking that she has 7 whole minutes and doesn't need to pay attention to us until then.
That probably makes sense.
Okay, but Cameron, Maria got y'all. Jason, gotcha. Thank you. Okay. Tyler, Paulina, got y'all. Is your second chairs, are they on?
Yes, my second chair is here, and I just want to confirm that everybody can hear me.
Yes, we can hear you just fine.
My second chair is also here.
Good, and we can hear you just fine as well. Okay. And our witnesses, Emma, Sam, are y'all on? Jordan, can you see and hear us?
Yeah, I can.
Okay, good. Can our witnesses turn on their camera real quick and just confirm that we can see and hear you? Sam, Emma? Good, thank you, Sam.
Can you hear me?
Yeah, good. Okay, thank you. Okay, we've got everybody. Judge Harris will be here in a few moments, and then we will get rolling as soon as he comes in and sits down, since we've kind of got at least the tech preliminary stuff handled. So Tyler, Paulina, thank you for your patience. See y'all in a few minutes.
All right, ladies and gentlemen, we will
proceed at this time. This is cause number TGCV-001-21 styled Jordan Gilmore versus Chimes Department Store. And at this time, is the plaintiff ready to proceed?
Yes, Your Honor. Before we go to opening statements, permission to make introductions before the court.
Yes, ma'am. We'll do that in just a moment. Is the defendant ready to proceed?
Yes, Your Honor, we are ready to proceed.
You all may make introductions, then I'll hear any housekeeping, pretrial type matters that you may have.
Good morning, Your Honor. My name is Paulina Pisetsky, and I, along with my co-counsel, Ms. Natalie Bayer,
Good morning, Your Honor.
we represent the plaintiff in today's case, Ms. Jordan Gilmore.
Good morning, Your Honor. My name is Tyler Jeffries. My last name is spelled on the screen, and it is spelled Jeffferes. I, as well as my co-counsel, Marina DeRosa, who just appeared on screen, represent Chimes Department Store, as well as Reese Geller in this matter. Your Honor, we have a couple of housekeeping matters. May I proceed?
Your Honor,
Let me find out if plaintiff has any before the.
yes, we do, Your Honor. Should we ask to share our screen constructively outside the presence of the jury with any exhibits, just so that Your Honor and opposing counsel were all on the same page?
As long as these are exhibits that have not yet been admitted, then yes, you need to do that. Once the exhibits have been admitted, you're free to show them to the jury as you desire.
Perfect. And then would you like us to approach the bench when making objections today?
No, only if it's a matter that for some reason or other specifically needs to be heard outside the presence of the jury, but your garden variety hearsays and things, no, we just do those from the well.
Absolutely. Should we formally ask to tender witnesses as experts, or just proceed with foundation and ask opinion questions?
It doesn't matter to me one way or the other. I have no problem with it.
Absolutely. And then, as Your Honor knows, this is a negligence action, and the court provided the parties with 4 sets of jury instructions that differed based on the defendant's intended theory of the case. And today, before we met, the defense has indicated during pretrial that they are using jury charge number 4, which lists Jordan Gilmore, the landlord Kermit Realty Co., and Chimes Department Store as potentially liable. And we appreciate the defense letting us know in advance so that we're all on the same page before we begin trial today.
Anything by the defense?
Yes, Your Honor. When impeaching or refreshing recollection, may we post the witness's deposition to the screen for the ease of the witness in the court?
You may share it with the witness themselves. Yes, not with the jury.
Understood, Your Honor. And finally, may we have the correct pronunciation of Your Honor's last name?
Harris.
Thank you, Your Honor. With that, we do have a couple of motions that we would like to address.
All right.
Your Honor, would you like to hear motions from the plaintiff first?
If plaintiff has one, let's go.
Yes, we do. So we went with opposing counsel and we stipulated to the admissibility of the following pieces of evidence, and we would like to move them in at this time. It's quite a long list, so I'm not sure if Your Honor wants to take out a pen, but the list is 1, 2, 3, 4, 6 and 7, 11, 12, 16, 17, 18, 19, 21, 31, 32, and 33. A majority of those are photos of the property, just so Your Honor is aware. We've also agreed to exclude evidence pieces number 8 and 9. And then, Your Honor, the plaintiff does move to exclude the testimony and an associated exhibit, number 36, from a defense witness, Perry Hayden, as irrelevant without a condition being met pursuant to Rule 104B, as it is substantially more prejudicial than probative under Rule 403. So by way of background, Your Honor, this is a negligence action in which my client, Jordan Gilmore, a former employee of the defendant company, fell off stairs that were in the designated break area for employees of the company. Now, Ms. Gilmore has alleged that the defendant negligently failed to maintain those stairs in January of 2019. But the testimony and exhibit we're asking to exclude, it relates to an inspection report that the defense witness, an OSHA inspector, prepared after visiting the defendant's company a year before the accident that we're talking about today. And the defense witness concludes that there's no violations of workplace safety standards. But we do not believe that the defense will be able to offer any evidence that the site of this inspection, the place where Ms. Gilmore fell, was in the same or substantially same condition on the day of the fall as it was on the day of that inspection a year before the fall. So unless and until the defense can lay that foundation that connects the conditions of those stairs at the time of this report a year ago to the condition of the stairs at the time of that accident, this report, it's not relevant. And it would mislead the members of the jury into assuming that the findings in that report are dogma. And we ask that that report and any related testimony to that inspection be excluded.
Response by the defense.
Yes, Your Honor. Before I respond, were the exhibits that a plaintiff's counsel listed admitted into evidence?
Those that were listed as having, yes, been, excuse me, as having been pre-admitted are admitted. Of course, those that have been excluded, I believe that was 8 and 9 are excluded.
Yes, Your Honor. Thank you. I just wanted to be clear. In response to the objection to Perry Hayden's testimony, Perry Hayden has been an OSHA inspector for over 13 years. He has many degrees within the area of OSHA inspection and regulation. Now, as to the fact that it would be irrelevant, Your Honor, the timing of this is actually 7 months. And within those 7 months, if the defendant is allowed to testify, Reese Geller will testify that nothing was changed within those 7 months, that everything remained in the same or substantially the same condition. They didn't add anything afterwards. They didn't fix anything on the concrete. And that was because this report, this inspection stated that they didn't need to, that this inspection revealed no violations of the OSHA regulations. Now, this is entirely relevant regardless of it being 7 months prior, because in those 7 months, nothing changed.
Your Honor, if I may.
Well, let's just stop there. I think trying to determine whether or not a piece of evidence is admissible at this point or should be excluded is cart before the horse. We'll get there, and if I'll make my ruling when the appropriate time arises.
Absolutely, Your Honor. With that, plaintiff has no further motions.
Your Honor, may I clarify your ruling? I just have a quick question. So I understand regarding the exhibit itself. Now, regarding testimony, in order to lay that foundation, we will have to read through the deposition that regards the inspection. Will that still be admissible to do in order to lay foundation for that exhibit?
Well, we'll wait and see what the testimony has been by that point, and then if I have to take some of the testimony outside the presence of the jury.
Understood, Your Honor. With that, I do want to clarify the stipulation pertaining to this being a bifurcated trial. The stipulation was that this is a bifurcated trial and that the plaintiff will not go into the nature or the extent of the injuries incurred, and as well as excluding exhibits 8 and 9.
Yes, this is just purely liability. The fact that, of course, the plaintiff is welcome to testify they were injured or she was injured. I mean, that's kind of prima facie to this whole matter, but past that, the extent of the injuries are not necessary.
Yes, Your Honor. And then I do move to exclude any mention of Chimes Department Store adding a light switch after this accident onto the load to control the light that was outside on the loading dock where this accident happened. This is a subsequent remedial measure and must be excluded pursuant to Federal Rule of Evidence 702. Or excuse me, 407. I apologize, Your Honor. Got my wires crossed there.
Response?
Yes, Your Honor. Rule 407 explicitly allows evidence of subsequent remedial measures for the purpose of proving a company's control over a particular area. So in this case, there's a critical dispute over whether the defendant, Chimes Department Store, or the landlord, Kermit Realty Company, controlled the area in question. And as such, this evidence fits squarely within the permissible uses of subsequent measures evidence under the plain language of Rule 407, and it wouldn't violate that rule.
May I be heard, Your Honor?
Very quickly, we're getting well into the, all right, go ahead.
While 407 does allow subsequent remedial measures to be used for control purposes, the plaintiff has multiple other ways to show control. For example, there's a lease agreement, live testimony, deposition testimony that the plaintiff can use to attempt to show control. Further, we are not arguing that there wasn't a way for them to put in a switch. And when testifying, Reese Geller will explain that they didn't control that outside area. They couldn't make any changes to the outside area. This switch was installed on the inside of the store, which there is no dispute of control on the inside of the store where this switch was installed. Therefore, it doesn't fall under any dispute of control because we're not disputing the control of the inside of the store, Your Honor.
Well, but did the switch control the light that was on the outside?
It did control the light that was on the outside, Your Honor. However, legally, they were not allowed to alter anything with that light, such as changing the light bulb even. We were not disputing that there was no control of the light switch that is now on the inside, but we are disputing the control of the outside dock, yes.
Well, again, I'll see how this goes when we get to the testimony on it, but it sounds to me like something that probably is going to be admissible, but again, I'll deal with that when I get there, so.
Your Honor, pursuant to your ruling, may we have no mention of this light switch in opening statements until we do get to the foundation?
That's fine.
Thank you, Your Honor. And with that, we are ready to move to opening statements.
And let's proceed with opening statements.
Your Honor, permission to set up my camera for one moment, please.
Ma'am.
Your Honor, can you hear and see me okay?
I can.
Perfect. May it please the court. They failed to fix, failed to inform, and they failed to warn. You're going to hear me say those three things over and over again today. The defendant, Chimes Department Store, failed to fix, failed to inform, and they failed to warn. The evidence today will show that because of this defendant's failures to fix, to inform, and to warn, well, one of its employees, Jordan Gilmore, got hurt. Ms. Gilmore, could you turn your camera on for a second so that the members of the jury can meet you? Members of the jury, this is Jordan Gilmore. She's 48 years old, from right here in Waco. She goes to church, she teaches Sunday school, and up until January of 2019, when Ms. Gilmore got hurt, she was a cashier at Chimes Department Store. And that's where our story begins and ends, Chimes Department Store. Thanks, Ms. Gilmore. You can turn your camera off again. I just want to spend a couple of minutes telling you about what you're going to hear and what you're going to see during our trial today. You see, on January 23rd, 2019, Ms. Gilmore, she's working her normal shift at Chimes. It's a big department store, kind of like Macy's. And Ms. Gilmore's job is to ring people up when they're done shopping. Now, on that day, Ms. Gilmore and her friend take a break during their shift. And you'll learn that the manager of Chimes says it's okay to take breaks. And that if employees want to smoke, well, they have to go outside to the back of the store. But that's not an option. It's the only place employees are allowed to smoke during their breaks. So that's where Ms. Gilmore and her friend go. Right here. these steps right here where her manager told them they had to go. It's dark outside. It's a cold, wintry day, and there's no light to show them the way. But the thing is, you'll learn that these steps, they were dangerous. Now, you'll get to see more pictures of these steps, and you'll see that that concrete, it was damaged, it was crumbling. Those steps were in a dangerous condition. Now, an expert in engineering, she'll tell you that those steps, they weren't up to code. They didn't meet the standards a business has to follow to keep its employees safe. And most importantly, you're going to learn that Chimes, its managers, and its owner knew those steps were dangerous. You'll hear that the defendant's managers knew that those steps were broken. They knew there were no guardrails. They knew there was no way for their employees to turn on the lights out there. But they failed to fix it. Failed to do anything about it. You'll hear evidence that the defendant had chance after chance to ask the landlord of the property to fix these broken steps too. But they didn't. They failed to inform that landlord. And even when the defendant knew that its employees would go out day after day after day onto that crumbling concrete with no rails and no lights, you'll learn that not once, not a single time, did the defendant warn its employees that it might be dangerous, to be careful, to pay attention. They failed to fix, failed to inform, and they failed to warn. So on that day, as Miss Gilmore goes outside to take her break, you'll learn she walks down those steps, takes her break, and as her break ends, she tries to come back up those steps, to keep on working, to keep trying to just make a living, to do an honest day's work. She slips on that loose concrete. She falls off that ledge. She lands hard on her right leg until her knee can't support her weight anymore. She's hurt. She's broken. And the evidence will show that Miss Gilmore was hurt only because this defendant failed to fix, failed to inform, and failed to warn. Now, Miss Gilmore, she has sued Chimes for negligence. That's why we're all here today, because the evidence will be clear. The defendant failed to do what they were supposed to do. They failed to fix, failed to inform, and they failed to warn. And once you hear all the evidence, I'll stand up again, talk with you one more time, and ask you to find the defendant liable. Thank you.
Defense.
Yes, Your Honor. May it please the court. Your Honor, Ms. Plasecki, and good morning, members of the jury. Ms. Plasecki just told you that Chimes is responsible for what happened to Ms. Gilmore. But the evidence will show that Chimes didn't cause that accident. It happened because of the actions of two other parties. The first party was Kermit Realty. They owned the building where Chimes was located and were legally responsible for building, maintaining, and providing lighting to the exterior of the building and the loading dock where this accident happened. And because of that, Judge Harris will tell you that you can assess liability against them for anything they did or didn't do in relation to building, maintaining, or providing lighting to that area. Now, Judge Harris will also tell you that you can assess liability against the plaintiff for what she did or didn't do that resulted in this accident. And the evidence will show that this accident wouldn't have happened but for what the plaintiff did or didn't do that day. Today, members of the jury, you're going to have to decide who is ultimately responsible for what happened. Whether it was Ms. Gilmore's conduct, the landlord's failures, or as the plaintiff claims, Chimes. When you consider the plaintiff's claims, I want you to remember that they bear the burden of proof in this case. They have to prove to you by a preponderance of the evidence each and every element of their case. And they will fail to do so because Chimes Department Store acted reasonably and responsibly, while the actions of the landlord and the plaintiff caused this accident to happen. And before we discuss that in more detail, let me tell you about Chimes and the store owner, Reese Geller. In fact, I'd like to introduce you to Ms. Geller right now. Ms. Geller, would you turn your camera on, please? Thank you. This is Reese Geller. Ms. Geller was born and raised right here in Waco. And after graduating from Baylor, she started working for her parents at Chimes Department Store and eventually took over for them when they retired. Thank you, Ms. Geller. You can turn your camera off. When Ms. Geller testifies later today, she'll tell you that the store had operated out of the same location for years, but eventually needed to go to a new location. So they moved to a strip mall. Now she'll tell you that before moving in, Chimes entered into a lease with the landlord that specifically outlined what areas the landlord controlled and maintained. You're going to see that lease today, which states that the landlord and the landlord alone was responsible for the building and the loading dock. That lease today will show you that the landlord and the landlord alone controlled the exterior lighting. That the landlord and the landlord alone was responsible for removing the guardrail. And you're also going to learn why the guardrail was removed. And simply, it's because you can't have a guardrail on a loading dock. Now, those are not my words. Those are the words of a professional engineer who will tell you that you can't have a guardrail on a loading dock. It defeats the purpose of the loading dock. And in fact, when the plaintiff testifies later today, she'll tell you the very same thing, that you can't have a guardrail on a loading dock. She'll admit that to you. That's not all the plaintiff will have to admit to you today. She'll also have to admit what she did or didn't do on January 23rd of 2019. You see, the evidence will show that January 23rd, 2019 wasn't the first day that the plaintiff walked out onto that loading dock. That she had been out there thousands of times over the last 10 years, but had never slipped, never tripped, never fell or had any sort of problem. But this time, she did things differently. She made choices and took risks, which resulted in this accident. Now, just a moment ago, Ms. Blazecki showed you a photo of a very small area of where this accident happened. But that's not the whole picture of where this accident happened. This is where the accident happened. This is where the plaintiff took her smoke break. This is where the defendant decided and took risks and made choices that placed her in danger. Members of the jury, safety is a two-way street. And on January 23rd of 2019, the plaintiff didn't act reasonably. She didn't act responsibly. She failed to pay attention. And that, together with the failures of the landlord, the actual reason that this accident happened. And that's why at the end of this case, I will ask that you remember these facts and that you follow the law provided to you by Judge Harris by finding Chimes Department Store not liable. Thank you.
First witness, please.
Yes, Your Honor. At this time, plaintiff calls Ms. Jordan Gilmore to the stand.
You all can presume that all witnesses have been pre-sworn.
Yes, Your Honor. Permission to inquire?
You may proceed.
Good morning.
Good morning.
Could you please state your name for the court?
Hi, my name is Jordan Gilmore.
What do you do for a living, Ms. Gilmore?
Well, currently I'm not working. I spend a lot of time at my church teaching Sunday school, things like that. But I used to work at Chimes Department Store.
Why don't you work at Chimes Department Store anymore?
Well, after the accident, I took some time to recover, but by the time I was ready to go back to work, they'd already replaced me.
We'll talk more about your accident in a moment, but before we get there, how long did you work at Chimes before you were replaced?
About 10 years.
And what did you do at Chimes?
I was a cashier, so I mostly helped with checkout and things like that.
Did you ever go out to the back of the store for any reason while you were working at Chimes?
Yes, I did. The dumpster was in the back. So that's where I had to take the trash when I was on my shift. And I also went out there for smoke breaks.
Would you recognize a photo of the back of the store if I showed it to you today?
Yes, ma'am, I would.
Ms. Bayer, could you please share your screen with what has been admitted as Exhibit 2? Thanks, Ms. Bayer. Ms. Gilmore, what are we looking at here?
This is the back of the store that we were talking about earlier.
And earlier, you mentioned that you had an accident. Where did you have this accident at the store?
Yes, it was right as I was taking my smoke break. I fell off of the landing that's shown here.
Now, is there a railing around the steps that we're looking at right here?
No, ma'am, there's never been a railing.
Were there any signs that said, "Be careful"?
No,
Were there any signs that said caution?
no,
Was there any reflective tape on these stairs?
no, nothing like that.
Well, in the 10 years that you worked at Chimes, was there ever a railing around those stairs?
No, ma'am.
Well, I can see a red circle in this photo. What is that circle?
Yes, that circle I drew, it shows where the light was outside.
And when did you draw that circle?
During my deposition.
Miss Gilmore, did that light work?
We did not have access to it in the store, so it was never on.
Well, when you worked at Chimes, do you know how that light turned on and off?
I believe that there was the switch for the light was in the Tractor Supply store, which was next door, but we did not have access to the light switch in Chimes.
Well, to the best of your knowledge, did anyone at Chimes have access to that light switch?
No, ma'am, I don't believe so.
Did you ever ask your supervisor about the light not being on at night?
Yes, we did.
And did your supervisor say anything to you in response to that complaint?
He just said that, we don't have access to the light, that they can't do anything about it.
Thank you, Ms. Bayer. You can stop sharing your screen now. Ms. Gilmore, you mentioned that you took your smoke breaks at the back of the store. Did you ever take smoke breaks anywhere else while you were at work?
No, ma'am, we were actually required to take them in the back of the store specifically.
And what required you to take them in the back of the store?
Management sent us a memorandum a while back requiring that we specifically take our smoke breaks there.
Would you recognize a copy of that memorandum if I showed it to you today?
Yes, ma'am, I would.
Ms. Bayer, could you share your screen with what has been admitted as Exhibit 1? Thank you. Now, Ms. Gilmore, what are we looking at?
This is the memorandum that management sent to us telling us where we should take our smoke breaks.
Has this memo, or excuse me, Ms. Gilmore, I want to direct your attention to that first paragraph of this memo. Could you read that paragraph for the members of the jury, starting with 2 sentences at the end of that first paragraph, as you have been told before?
Yes, ma'am. As you have been told before, if you're going to smoke, you need to smoke out behind the store where our dumpster is. This is the only place you should take smoke breaks on the premises.
Does this memo say anything about cleaning up the area?
Yes, it does in the second paragraph.
Could you read that second paragraph out loud for the members of the jury?
Yes, ma'am. Also, I've noticed lately that the area out by the dumpster has a lot of trash on the ground, including a lot of cigarette butts. So if you do take a smoke break out by the dumpster, please take some time to clean up the area, pick up any trash you see, and make sure that you dispose of your cigarette butt in a manner that doesn't add to the problem. We want to make sure to keep our area clean and presentable.
Was it your understanding that as a part of your job, you had to clean up that area?
Yes, ma'am, it was.
Thank you, Ms. Bayer. You can stop sharing your screen now. So, Ms. Gilmore, let's shift gears and talk about that accident now. What day did you fall off those stairs at Chimes?
It was January 23rd, 2019.
Were you working that day?
Yes, I was.
And what shift were you working that day?
I was working the closing shift, so it was noon to 8 p.m.
You mentioned earlier that you went to the back of the stairs that day. Around what time did you go to those stairs?
That was around 7 p.m.
Was it light outside?
No, it was winter, so it was pitch black at that point.
Why did you go out back?
I went out back to take my smoke break.
Did you go alone?
No, I didn't. A coworker of mine, Riley Huntsberger, went with me.
So what happened when you and Miss Huntsberger went outside?
Well, Miss Huntsberger stayed kind of on the landing area, holding the door open because I believe it was fairly windy that night. And then I walked down the stairs and smoked out next to the dumpster. And then I walked back up the stairs, and that's when I fell.
We'll get to that in one moment, but before we do, earlier you mentioned that there wasn't a railing on those steps. So did you hold on to anything while you walked down?
I mean, I did what I could. I tried to steady myself with the wall that was there, yes.
Now that light you showed us earlier, was it on?
No, ma'am, it was not.
Well, how could you see where you were going?
Well, as I mentioned, Riley was still standing up on the landing, and she was kind of holding the door partway open. So the only light was the light coming from the inside of the store.
So I want to get a better understanding of what that area actually looks like with that door open like that. Your Honor, I'm sharing my screen, or permission for Ms. Bayer to share her screen with what has been admitted as Exhibit 3. Thank you, Ms. Bayer. Now, Ms. Gilmore, what are we looking at right here?
This is a picture of the stairs that were out on the loading dock behind Chime's store.
Now, is that what the door looked like on the day of your fall?
Yes, it is.
Could you describe the condition of the stairs that we see right here?
Yeah, I mean, there's several holes, as you can see, and they're starting to chip.
Thank you, Ms. Bayer. You can stop sharing your screen now. So you mentioned that you got downstairs. What happened when you walked back upstairs?
Well, as I walked up the stairs, steadying myself on the wall, by the time I got up to the landing area, because Riley was holding the door open, trying to keep it from blowing around in the wind, there wasn't as much room up there because the way the door was being held. And so I tripped and fell, and, I did what I could to steady myself, but I, fell, landed on my butt. There wasn't anything else I could do.
What happened after you fell?
Well, I landed on my right side pretty hard. Riley came down to check on me, and I couldn't get up the stairs at that point without Riley's help. I knew that this wasn't good.
Did you speak to anyone from Chimes after your fall?
Yes, I did. We went to the manager that night, Lane Kim.
And what did Miss Kim say when you talked to her?
Well, she said, yeah, we probably should have fixed those steps a long time ago. I've talked to the owners about it a few times, but we always seem to have bigger problems to fix first. I guess I'm sorry about that.
Ms. Gilmore, did you ever go to the hospital?
Yes, I did the following day, January 24th, 2019.
Thank you. Your Honor, I pass the witness.
Oops.
Good morning, Ms. Gilmore.
Good morning, ma'am.
Now, you've been working at Chimes for about 10 years, right?
Yes, I
And
did.
You smoked the entire time that you worked at Chimes.
Yes, I did.
And you smoked about a pack a day, right?
On average, yes.
And you took at least one smoke break every shift, correct?
That's correct.
Out on the loading dock?
Yes, behind the store.
And you also went out to the loading dock to throw out trash, right?
Yes, ma'am. That was also part of my job.
And you said that you would go out there about twice a day to throw trash out.
Yes, once or twice a day.
And you estimated that you go out to that loading dock about 20 times a week?
Yes, ma'am. That sounds correct.
And this might be an odd question, but there's 52 weeks in a year, right?
Yes, I believe so.
And so if my math is correct, that would equal out to about 1,000 times in a year, right?
52 times 20. I'll take your word for that.
So 1,000 times in a year for over 10 years that you worked there, right?
Yes, 52 times 20, whatever that number may be.
Well, over the years, you would go out during the day,
Yes, sometimes.
and sometimes you would go out at night.
Yes.
And prior to January 23rd of 2019, you never fell.
No, I don't believe that I did.
You never tripped.
No,
You never slipped.
no.
And you never tripped, slipped, or fell because of any problem with the stairs, right?
No, not until January 23rd.
Prior to January 23rd, you had no problems with the concrete.
None that I recall, no.
And prior to January 23rd, you didn't fall because of any lighting issues, right?
No, ma'am, not that I recall prior to that date.
And I want to talk to you a little bit more about the lighting. You said that the lights weren't on regularly.
I don't recall the lights ever being on, if I remember correctly.
Right. And you said that you spoke about this to your supervisor.
Yes, ma'am.
You can't tell us the name of that supervisor you spoke to.
I don't know off the top of my head. I apologize.
You can't tell us the exact date of when you spoke to that supervisor.
No,
Can't give us even an approximate date.
no, I'm sorry, I can't.
But you do know that Chimes didn't control that exterior lighting, right?
Yes,
Objection. Oh, I'm sorry. Did I freeze? I thought that I froze. I'm so sorry. I was going to say objection, lack of personal knowledge.
objection was what now? I'm sorry.
Objection to lack of personal knowledge.
Response.
Your Honor, I asked the witness if she knew, and this was also addressed on opposing counsel's direct examination, that she understood that the light switch within the Chimes department store didn't control that light outside, and that there was no way for Chimes to control it from inside of the store.
Your Honor, if I may,
Quickly.
asking this witness whether or not they knew if the store had control over the light switch is different than asking them whether or not they knew if they could turn the light on and off. Since we are here to determine that specific legal term, whether or not the owners had control over that premise, it would be inappropriate to ask this witness, a lay witness, that question.
Well, if she knows, she can answer. If she doesn't know, she's perfectly free to say so.
Yes, Your Honor.
Ms. Gilmore, you knew that Chimes didn't control that exterior light, correct?
I knew that there wasn't a switch in Chimes and that the switch was in the Tractor Supply store next door.
Right, you knew that there was no switch in the store that turned that outdoor light on.
That's correct.
But Chimes did have interior lights in near the back door, right?
Yes, that was the only lighting that we had that night.
You would use that light source when you went out back.
Yes, Riley, like I said, held the door partially open, so we had some light.
I mean, you would do that every time you went out back at night, right?
I believe so, yes.
And you could do that by opening both of the doors?
I mean, the night of the accident, we only opened the one door, but I would imagine that you could open both.
Ms. Gilmore, I'm not asking you specifically about the night of the accident. I'm asking you in general. You could have opened both doors to get all that light out there?
I mean, I suppose it's possible, but like I said, the night of the accident, it was quite windy. So we were just trying to control as much as we could with the one door.
Again, Ms. Gilmore, I'm not asking you about the night of the accident. I'm just asking you in general. And you, in general, could use both doors to bring light to the outside, correct?
I suppose that's possible.
You could also use a flashlight.
I suppose that's also a possibility.
You could have even used your own iPhone.
Well, I didn't have my phone on me the night of the accident because, at work, I don't generally keep my phone on me at all times.
Right, but you could have used your phone on that night, correct?
I suppose that I could have.
Mr. Rosa, could you publish exhibit number 6, which has been admitted into evidence? Ms. Gilmore, this is a photo of the loading dock doors, right?
Yes, ma'am.
And there are 2 doors there.
That's correct.
The door on the left is the one that was open on January 23rd, 2019, correct?
That's correct.
But it wasn't open like it is in this picture.
No, not exactly.
It was only open about halfway.
That's true.
And you didn't open both doors, right?
No, we didn't. As I'd mentioned, it was pretty windy. So Riley was trying to, control the one door so it wasn't blowing everywhere.
Well, you didn't open the door on the far right?
No, ma'am, we didn't. As I mentioned, it was pretty windy.
Well, the wind wouldn't have stopped you from opening that door on the right, correct?
I don't really know.
Well, you didn't ask your friend to move so that way you could get more light from the door, right?
No, I didn't ask Riley to open the door more or anything like that.
You didn't ask Riley to open both doors?
No, ma'am, I didn't.
You didn't ask Riley to open the other door that would have led a clear path to the store, right?
No, ma'am, I didn't.
And you didn't stand with your friend right there on that landing, right?
I guess I'm a little bit confused by your question.
Sure, I'll clarify. When you took your smoke break, you did not stand with Riley Huntsberger right on that landing, correct? That we're seeing here in Exhibit 6?
No, I like I said, walked down to take my smoke break. And as I was walking back up, Riley was standing, kind of near the landing holding the door.
No one told you that you couldn't stand on that landing, right?
I don't believe so. Or yes, you're correct.
And no memos were sent out saying that you couldn't stand on the landing?
Not that I recall, no.
And no rules prevented you from standing there on that loading dock?
No, not that I know of.
Thank you, Mr. Rosa. You can take that exhibit down. No, instead, Ms. Gilmore, like you said, you walked down the steps.
Yes, ma'am.
You had your cigarette.
I did.
And then you headed back up those steps.
Yes, that was the easiest way to get back into the store.
Right. When you did that, you held onto the wall.
Yes, I did. I, tried to balance myself as best I could.
But that's not, or excuse me, you said you did that for safety purposes, right?
Just to kind of balance myself. Yes.
But that's not what you said on the date of or when you gave a report about the accident, correct?
I don't, I'm not sure.
You gave a statement to your supervisor after the accident, right? Concerning the accident?
Yes, ma'am, I did.
You stated exactly what happened that day?
I believe so, yes.
Everything that you did and didn't do?
Yes, ma'am.
Nowhere in that statement did you say that you hung onto the wall?
I don't believe I did.
Nowhere in that statement do you complain about the lighting?
No, that's correct.
And nowhere in that statement do you complain that there was no guardrail?
That's correct.
And now, before we get to the guardrail, I want to talk to you about something that you said on direct.
Yes, ma'am.
You said on direct that Lane Kim told you that they had spoken to the owners about the lighting, correct?
I don't recall exactly. I believe that I complained to management generally about the lighting, but I don't recall specifically.
After your accident, you said that Lane Kim told you that they had spoken to the owners and they knew that they should have done something about it, correct?
Yes, that was about fixing the steps.
Fixing the steps. I apologize for my confusion.
No,
No.
you're fine.
Now, you don't know who she was referring to when she was talking about owners, right?
No, I don't know.
You don't know if she was talking about the owners of Chime Department Store?
I mean, that's possible, I guess, but I'm not really sure. She just said owners, so that's all I know.
That's a yes to my question. You don't know if she was talking about the owners of Chime's Department Store?
I mean, she said owners, so
You don't know if she was talking about the owners of the building?
I guess that's a possibility.
And now, you never complained that there was no guardrail out on the loading dock, right?
That's true.
And you didn't complain about the guardrail because it wasn't an issue for you?
It wasn't an issue until it was when I fell.
Well, it wasn't an issue for you because according to you, a guardrail was not needed, right?
That is true. Yeah, I mean, it was a loading dock.
Right. And in your words, how could you put a railing on a loading dock?
Right. It was kind of a problematic situation.
Thank you, Your Honor. No further questions.
Redirect.
No redirect, Your Honor.
Next witness.
Yes, Your Honor. At this time, we'd like to read to the jury portions of a deposition by a witness named Kelly Danes. Now, both parties have stipulated that Ms. Danes is unavailable as defined in Rule 804A.
Yes, ma'am.
We respectfully ask the court whether it intends to instruct the jury on how the jury should treat deposition testimony as compared testimony to a live witness, and if so, whether the court would like to do that now or at the end of trial.
Well, I'll do it now. Ladies and gentlemen of the jury, deposition is testimony taken of a witness outside the courtroom. However, it is taken with the same solemnities as within the courtroom. The oath is administered to the witness. The witness is told that their testimony at that point has the same force and effect as if the jury were sitting there listening to that testimony being taken, and that just as in any other case under oath, that they're subject to penalties of perjury, things of that nature. And so what you will hear are the questions that were asked by the attorneys in the exact way they were asked, and you will hear the answers usually read by a different person, but it is the answer of the witness that was given at the deposition word for word. And you may take that as if this witness were here testifying before you today. You may proceed.
Is it all right if I have my co-counsel, Natalie Bayer, read the answers as I read the questions, Your Honor?
Yes, ma'am.
All right. Starting on page 2, line 6. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Kelly Danes.
Going to page 2, line 12. Tell us about your education.
I have a Bachelor's of Science in Mechanical Engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person/builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically, some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
What do you have to do to become a professional engineer?
Well, you have to graduate from an accredited engineering program, which I did. Then you have to pass the fundamentals of engineering exam, which I did. Then you work as an engineer for 4 years before you take the professional engineering exam. So I took that as well and I passed.
Going to page 3, line 13. What do you do professionally?
I'm the president of Danes Engineering, LLC.
What does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Going to page 5, line 14. All right, Kelly, I want to move on and talk about your work in this case. What did you review in coming to your opinion in this case?
I reviewed the depositions of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, or OSHA, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Going to page 6, line 18. What do these pictures show?
Well, as you can see, there are no railings on the steps up to the landing area, and there's no railing on the landing area itself. Plus, you can see where the railing used to go into the concrete and how the concrete around those areas is worn down and cracked. So you can see that this is a pretty dangerous situation.
Going to page 9, line 9. All right, so which portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photos that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such a program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and the OSHA regulations.
Skipping ahead to line 10 on page 10. Well, the OSHA regulations apply to the place of employment, right? Are those stairs part of the plaintiff's place of employment?
Well, she wasn't out there working at the time she fell. She was on a smoke break, but she had been instructed to use that area for her smoke breaks, and Chimes uses that area as a loading dock and requires employees to throw trash in the dumpster in that area. So it seems like a place of employment to me.
Going to page 11, line 6. What other portions of the IBC codes and the OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs, but there was no switch for that light inside the Chimes store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Going to page 12, line 1.
Next, we move to OSHA 1910.23 D1 and 1910.24 H and IBC 1009.11.
Why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there was no guardrail on these stairs on the exposed side, which is obviously dangerous.
And finally, going to page 14, line 22. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the door shall not project more than 7 inches into the required width. When the door is open like that, like it was at the time of this incident, it obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the plaintiff fell.
We have nothing further from this witness at this time, Your Honor. Thank you.
Any cross-examination?
Yes, Your Honor. My co-counsel may be used as the witness. Beginning on page 3 with line 22. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Moving down page 4 to line 21. How did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time that I've consulted in one of their cases.
Guess that means they liked what you did in those other cases?
What can I say? I'm good at what I do.
Objection, speculation,
Sustained.
permission to strike that testimony, Your Honor.
Granted.
Moving to page 10, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations, and basically have to be responsible for their own actions.
And finally, moving to page 14, line 5. Do either 1910.24 or 1012.1 apply to loading docks?
They don't mention loading docks specifically, but this wasn't a loading dock.
And going down to, oh, I apologize. Why do you say that?
Well, just look at how it was used. Employees used this area to throw trash in the dumpster and used it to take smoke breaks. So this wasn't just a loading dock.
So you would agree, though, that this area was used by Chimes as a loading dock at times?
Yes, at times.
And a guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock?
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employers or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
Your Honor, with that, we have completed our reading of Kelly Dane's deposition.
Anything further with this witness by the plaintiff?
No, Your Honor. With that, the plaintiff rests.
All right. Well, we take about a 5-minute recess, let the defense get ready for their case in chief.
Yes, Your Honor.
All right.
Your Honor, when we return, could we get a time check?
Yes, you can. I'll have it ready by the time we get back.
Thank you.
We'll take 5 minutes. All right, council time checks. Plaintiff, you've got 29 and a half minutes remaining, and the defense You've got just shy of 36. So we'll give our jurors just a second longer to join us, and then jurors, if you will, turn on your microphones and I'll do a check just to make sure everybody's back. All right, Ms. Giroux, I see you're back.
Yes.
And Mr. Bernard, you back?
I'm here, Judge.
Ms. McIntyre back?
Yes, Judge.
And let's see, is that everyone?
I'm back as well, Judge.
Trying to, these names jump around on here so much, I can't tell who was that just said they were back.
It was me, Judge.
Okay, very good. Then we will proceed with the defense's first witness.
Your Honor, the defense calls Reese Geller.
You may proceed.
Ms. Geller, please introduce yourself to the jury.
Hi, my name is Reese Geller.
Where do you live?
I live right here in Waco.
Do you have any family here in Waco?
I do. I'm married to my sweet husband, Peyton, and we have 3 young kids. There's Jerry, he's 10. We've got Jim, who's 7, and our sweet little baby girl, Liz, who's 4.
And did you go to college at all?
I did. I actually went to Baylor University right here in Waco. I was a business major. Thought about going and doing an MBA, but too much school for me.
I understand that. What do you currently do for a living?
So I'm currently the owner of Chimes department store here in Waco.
How did you get to be the owner of Chimes Department Store?
So Chimes is a family business. My parents had Chimes and I worked my way up from being a buyer and put in a lot of hard work, and now I'm the owner and they turned the business over to me.
And how long have you been the owner?
For about 10 years now.
And what kind of store is Chimes?
So I like to describe Chimes as like a J.C. Penney or a Macy's. We do a little bit of everything from, clothes to shoes and tools and anything that you could possibly imagine.
Is Chimes a big chain like J.C. Penney or Macy's?
No, we're a sweet mom and pop type store.
How many locations do you have?
Just the one.
And do you know why you're here today?
Yes. Jordan Gilmore, one of our employees, has sued us for negligence in regards to our loading dock and an unreasonable work condition.
And why did he bring this lawsuit? What happened that occurred that made him bring this, or made her bring this lawsuit? Excuse me.
Miss Gilmore fell from our loading dock, which has some stairs towards the back of our building. And that's what caused this lawsuit.
And you mentioned a loading dock, and we've talked about a loading dock quite a bit today, but what is a loading dock?
So a loading dock is where, big trucks like 18-wheelers are able to back in, and it provides easy access to get all of the merchandise out of the truck. So it's a raised platform to where you can stand and walk directly into the truck instead of having to walk up the stairs of the truck and then walk it back down and into the store.
And describe to us what your loading dock area looked like.
So our loading dock, it's located at the back of our store, and there's 2 doors that open up to the stairs. There's about, I want to say 5 stairs. It's just a cement stairway, I'm sorry. And there was a guardrail originally because it was just an exit where, employees or anybody could just walk out of the store from the back exit. But we wanted it to become a loading dock, and so we had to take down the railing in order for it to function as a loading dock.
No, were you allowed to just take down the railing whenever you wanted to, or was there a process to do that?
There was definitely a process to doing that.
What was that process?
So I actually had to send an email to our landlord and make that request in order to have the guardrail taken down.
And why did you have to send this email to your landlord?
Under our lease, it was required because Chimes does not control, nor are we responsible for that area of the loading dock. And so we had to get permission in order to have that guardrail taken down.
Now, you mentioned your lease. If you were to see portions of that lease, would you be able to recognize it?
Yes, absolutely.
Mr. Rosa, can you please publish Exhibit 11, please? Pages 9 and 10 from Exhibit 11 that has already been admitted into evidence. Thank you. Ms. Geller, can you see that?
Yes, I can.
Now, on page 9, do you see the section that says that is Article 6.1?
I do.
Mr. Rosa, could we zoom in on that so that way we can make it a little bit easier for Ms. Geller? Thank you. Ms. Geller, what does this article of your lease mean to you?
So to me, the language is talking about, the common area. And that's, it's the area that's not Chimes. So we lease portions of Kermit Realty Group's property, and upon that property is also the building. And so we have designated areas that are under our control as the lessee, and the common areas are the areas that remain under the control of Kermit Realty Group.
And now, do you see on page 10, Article 6.3?
I do.
Mr. Rosa, could we zoom in on Article 6.3, please? Thank you. Ms. Geller, what does this article of your lease mean to you?
So this one's talking about who's responsible for the common area. And so the landlord, Kermit Realty Group, is the one who is responsible for, operating and maintaining and ensuring the safety of the common areas.
Now, based on your understanding, was the loading dock a common area?
It was not. Or sorry, it was. I apologize.
That's okay. So just to be clear, the loading dock was a common area?
Yes, the loading dock was a common area under our lease.
And under your lease, who controlled the loading dock?
Because it was a common area under the lease, the landlord, Kermit Realty Group, controlled the loading dock.
Thank you, Mr. Rosa. You can take that down. Now, Ms. Geller, prior to this accident, did you ever inspect the loading dock?
No, it wasn't something that I was going to check. I mean, we're a department store, not necessarily a safety company, so I did not.
Did anyone who has those qualifications inspect the loading dock?
Not to my knowledge.
Do you recall having an OSHA inspection done?
I do not.
Okay. Do you recall ever having any sort of inspection done in 2018?
Yes.
And who conducted that inspection?
It was through OSHA. We at Chimes don't conduct any safety inspections, but we do tell our employees to let us know if there's any issues.
Right. And so you mentioned that OSHA inspected the premises, the loading dock. Do you recall the date of that inspection?
I believe it was it 2018? I'm not sure that I recall.
Would May 5th of 2018 ring a bell?
Yes, it does.
And now after May 5th of 2018, did you change anything on the loading dock?
No, we did not.
Now, earlier we were talking about your lease and we were talking about areas that you own and didn't own. Part of your lease, there's a site map, right?
Yes.
If I showed you a copy of that site map, would you recognize it?
Yes, it would. Sorry.
That's okay. Mr. Rosa, could you please publish Exhibit 12, which has already been admitted into evidence? Ms. Geller, what are we looking at here?
So this is a site map of the property on which the building sits and where the loading dock is located.
Now, I noticed that there's cross hatches. What do those mean?
So the crosshatches, as we discussed earlier with the common areas under the lease, the crosshatching area is the area that Chimes is responsible for the maintenance and control of, while the non-crosshatched areas are under the control of the landlord.
And now, do you see at the top of this site map the red X?
I do.
Who made that red X?
I believe I wrote the red X on there.
And what does that red X indicate?
That's the location of the loading dock.
And underneath that red X, are there any cross hatches underneath there?
Directly underneath, no.
And so what does that mean to you?
That means that the loading dock is a common area, which is under the maintenance and control of the landlord Kermit Realty Group.
Thank you, Ms. Geller. I have no further questions. And Mr. Rosa, you can take down Exhibit 12.
Did you pass the witness?
Yes, Your Honor, I passed the witness.
All right, you may proceed.
Good morning, Ms. Geller.
Good morning.
Now, I want to pick up right where you left off, talking about that map that we saw. Ms. Baer, could you pop Exhibit 12 right on the screen for us here? Thank you. Okay, so I want to talk a little bit more about this X. So that X is actually where Miss Gilmore got hurt. Isn't that right?
Yes.
And the part where that X is, it's right behind your store.
Yes.
Meaning that there's a door to get from that area to where the X is, right?
Correct.
Now, your employees, they use that area where the X is.
Yes.
And you know that they use it every day.
Somewhat regularly, yes.
Well, in fact, you're aware that your managers, they tell them to use it.
Yes.
Your managers tell them to take the trash out back there.
Yes.
To clean up the area near the dumpster, right?
Yes.
And to take breaks back there.
Yes.
At all hours of the day.
Yes.
And even into the night.
Yes.
So you told us on direct examination that you use this area for loading items into your store off of trucks, right?
Correct.
Now, when you first signed this lease, there was a railing near the back stairs. Is that right?
Yes.
And you told us on direct examination that you believe Kermit, the landlord company, they were in charge of that loading dock.
Yes.
Now, because of that, you asked for the railing to be removed. Is that right?
It is.
And specifically, you asked your landlord to remove it.
Yes.
So you sent an email to that landlord.
Yes.
And you would recognize that email if I showed it to you today, right?
I would.
Your Honor, permission to publish outside the presence of the jury what has been previously marked as Exhibit 13 for identification?
Yes, outside the presence.
All right. Ms. Geller, do you see Exhibit 13 right here?
I do.
So that's an email that your company sent to your landlord, Kermit, right?
Yes.
And that email is your company email, right?
Yes.
It was sent by your father, who was president at the time, correct?
Correct. Yes.
There have been no changes made to this email since the last time you've seen it, right?
No.
Your Honor, at this time, defense moves, or plaintiff moves into evidence, plaintiff's Exhibit 13.
Any
No,
objection?
no objection, Your Honor.
13 submitted.
Permission to publish the jury, Your Honor?
Granted.
All right. Now, over the last 15 years, because of this email, you've been able to use that loading dock to load items into your store. Is that right?
Yes.
Okay. Thanks, Ms. Barrett. You can stop sharing your screen now. But isn't it true that this isn't the first time that someone got hurt on that loading dock out there?
That's true.
You got a complaint about that loading dock in 2010, right?
Yes.
And that's because an employee got hurt on that loading dock in 2010.
Yes,
And you would recognize a copy of that accident report if I showed it to you, right?
I would.
Your Honor, permission to share my screen outside the presence of the jury with what has been previously marked as Plaintiff's Exhibit 14 for identification.
Right.
Ms. Bayer, could you share your screen? Thank you so much. Now, Ms. Geller, do you see Exhibit 14?
I do.
So this is a copy of a recorded statement concerning that accident involving one of your employees, right?
Yes,
And the interview for this accident, it was taken on January 12th, 2010.
that's correct.
It was taken by an April Nardini.
Yes,
Now, she was a supervisor at your company at the time.
that's correct.
And your supervisors, they're required to take reports like this anytime there's an accident, right?
Yes,
And you have reviewed this accident report as a part of your job, right?
I have.
Your Honor, at this time, plaintiff moves into evidence, Plaintiff's Exhibit 14.
No objection, Your Honor.
14 submitted.
Permission to publish, Your Honor?
Granted.
All right, now I want to draw your attention, Ms. Geller, to the accident loss section of this document. So this section, it describes the accident that occurred. Is that right?
It does.
And based on this section, you know that an employee was walking down the steps at that loading dock, right?
Yes,
That he slipped on some loose concrete,
yes, that's what it states.
specifically because there was nothing to grab onto.
Yes, that's what it states.
Now I want to turn your attention to the bottom of that document where it says for Chimes use only. So just to be clear, this part, it's filled out by the manager who took the statement, right?
Yes,
Now I want to focus in on that last section, that last question in that section we see highlighted right there. It asks, are there any steps that should have been taken by Chimes to help prevent such injuries in the future, right?
yes, that's what it states.
And then the manager responds, make sure there's adequate lighting on the loading dock.
That's what it states, yes.
Thanks, Ms. Berry. You can stop sharing your screen now. So after this accident in 2010, you didn't tell the landlord to fix the lighting, did you?
No,
You didn't fix the lighting.
no, the light wasn't under our control.
I'm not asking whether it was in your control. I'm asking whether you fixed the lighting, and you didn't, did you?
No,
You didn't tell the landlord to fix those steps either.
no,
You didn't fix those steps.
no,
And then 9 years passed, right?
yes,
And in those 9 years, employees kept using that landing area.
yes,
Your employees kept using those steps.
yes,
And during those 9 years, you knew that those steps were broken.
I suppose it's possible.
Well, Miss Geller, I'm going to share my screen with what has been admitted as Exhibit 3. I want to take a look at this document really quickly. So you can see right here, you'd agree with me that those steps, there was a break in that step, right?
Correct, they're worn.
Right, and there's a exposed pipe from where the railing was, right?
Yes,
And there's some crumbling in the concrete around that exposed pipe, right?
yes,
Now, you knew about the condition of these steps before January of 2019, yeah?
yes,
But you didn't pay to have these steps fixed, did you?
no,
And you didn't ask your landlord to fix these steps, did you?
no,
Then, in January of 2019, Miss Gilmore, she falls on these steps
yes,
in the dark
yes,
where the light was not on.
correct.
But after that accident, you didn't make that area safer, did you?
We fixed the light switch situation.
Okay, well, I want to talk to you about you fixing the light situation. Miss Berry, you can stop sharing your screen now.
Objection, Your Honor. May we sidebar?
But
Pursuant to your honor's ruling, you reserved on this motion to exclude any testimony pertaining to the light switch being fixed or being installed inside of the Chimes department store. I do believe that this line of questioning is going to head into that direction.
my court, as you pointed out earlier, reserved a ruling on that to determine whether or not we got to an issue of control, and I think we're there. And I do think that at this point, the evidence is probative to prove control. So,
Your Honor, may I be heard briefly?
no, I've ruled, so let's move along.
Understood, Your Honor.
Ms. Geller, yes, Your Honor. Ms. Geller, so just to be clear, you installed a switch inside the building that turns the light above the steps on and off. Is that right?
Yes.
No, you didn't ask your landlord to do that.
No.
You just did it, right?
Correct.
You installed that light switch inside of your building
Yes.
after Ms. Giller fell on those steps. Is that right? Or excuse me, Ms. Gilmore fell on those steps. Is that right?
Yes.
Thank you, Ms. Geller. Your Honor, I have no further questions. I pass the witness.
Any redirect?
Briefly, Your Honor. Ms. Geller, you were asked about the prior incident. Do you recall the year that incident happened?
Yes, I believe it was 2010.
And do you recall the year of your OSHA inspection?
It was 2018.
Between 2010 and 2018, do you recall making any changes?
Objection asked and answered.
Oh,
I'll repeat my question. In the time between 2010 and 2018, do you recall making any changes?
No.
And after that inspection, do you recall making any changes?
No.
Thank you, Your Honor. Nothing further. I just asked that the witness be excused.
Any recross?
No recross based on that, Your Honor.
It's my step down. You're next.
Your Honor, the defense calls by deposition Perry Hayden.
All right, you may proceed.
Beginning with page 2, line 5. Good afternoon. Can you please state your name for the record?
Good afternoon. My name is Perry Hayden.
Moving down to line 11 on that same page, what do you do for a living?
I'm a compliance, safety, and health officer with the Occupational Safety and Health Administration.
What does the Occupational Safety and Health Administration, or OSHA, do?
OSHA is the government agency that is responsible for making sure that workplaces are safe for the employees that work there. So we provide information, training, and assistance to employees and employers to try and make workplaces as safe as possible and to make sure those workplaces are in compliance with OSHA regulations and standards. They're all about employee safety.
And what do you do at OSHA as a compliance, safety, and health officer?
I'm one of the people from OSHA that goes out and inspects workplaces on a regular basis to see if that workplace is in compliance with OSHA standards.
What happens if a workplace doesn't comply with those OSHA standards?
Well, there are lots of potential implications, but at the very least, it would result in a citation for any violations that we find, when the employer would have a chance to correct the issues that we find. Then, if they fail to take corrective steps, we might issue fines.
Moving down to line 16 on that same page, how long, or on page 3, excuse me, how long have you worked for OSHA?
Since I got out of school, so at this point, that's about 13 years.
And over that time, how many inspections have you conducted?
Oh man, hundreds, thousands. I mean, the answer is a lot. It's basically my entire job. So I'm always out on the road inspecting somewhere. It's an everyday thing.
What kind of education did you receive before becoming an inspector for OSHA?
I graduated from high school and then I went on to Texas State Technical College, where I got an associate's degree in occupational safety compliance technology. Then I went on and got a second associate's degree in environmental technology compliance.
Moving to page 5, beginning with line 6. All right, Ms. Hayden, how are you involved in this case?
Well, I conducted an inspection at the Chimes department store in Waco back in 2018. So I assume that's why I'm here.
Your Honor, Your Honor, we have what has been pre-marked for identification as Exhibit 36. May we constructively post outside the presence of the jury for it to lay the foundation through this deposition?
You may.
Thank you. Thank you, Mr. Rosa. Ms. Hayden, I'm showing you what has been marked as Exhibit 36. Do you recognize this?
Yes, this is my report for my 2018 inspection of the Chimes department store.
Is Exhibit 36 a true and correct copy of the report regarding your 2018 inspection of the Chimes department store?
Yes, it is.
Your Honor, we move to admit what has been pre-marked for identification as Exhibit 36 into evidence as Exhibit 36.
Well,
Your Honor, if I may object, this is what our pre-trial motion dealt with, specifically this exhibit and the testimony relating to this inspection.
yes, ma'am. And again, your argument was, as I recall, essentially this was approximately a year before. And then maybe the other counsel said 7 months. Is that right?
Yes, Your Honor.
And what other basis for your objection was there other than the passage at that time?
What are the other bases? Well, that no one can prove that this property is in the same exact condition as it was on the day of the accident. And just because the company's CEO said on direct examination that there weren't any changes doesn't mean that that area hasn't deteriorated, when she specifically testified on cross-examination that people used that area every single day.
That goes to the weight more than admissibility. So objections overruled, 36 submitted.
Yes, Your Honor.
Your Honor, may we publish this Exhibit 36 to the jury?
You may.
And now moving on, we are still on page 5, but going back to line 16. Why did you inspect the Chimes department store in Waco back in 2018?
It was just a regularly scheduled inspection. We do that all the time. Just show up and do an inspection.
Moving to line 23. During that inspection, what were you looking for?
At the most basic level, I'm looking for any kind of condition at the workplace that might be dangerous to the employees working for Chimes.
How do you determine if a condition is dangerous?
Well, if a condition on the premises doesn't comply with the standards under the OSHA regulations, then it would be dangerous, and that would necessitate a citation.
Did you issue any citations to Chimes as a result of your inspection back in 2018?
No, I did not.
Thank you, Mr. Rosa. You can take down Exhibit 36. Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Moving down to line 22 on page 6. When you went out there, what did you notice about the steps and that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Moving to line 9 on page 7. If there was such obvious safety issues, why didn't you issue any citations?
As I said, I got pretty alarmed, so I asked the manager that was walking around with me during the inspection about the fact that there were no guardrails and about the cracked concrete. The manager told me that there used to be guardrails, but they were removed because Chimes used that as a landing area and as a loading dock.
Why does that matter?
Because loading docks don't have to have guardrails.
How do you know that?
Because OSHA says so.
Moving to page 8, line 20. Is there any OSHA regulation that does specifically discuss loading docks?
Yes, 1910.28 B1 III clearly states that guardrails aren't required on loading docks because they aren't feasible. You can't very well load something onto a dock with a bar in your way.
Moving to page 9, line 12. Was this area behind the store exclusively used as a loading dock?
No, it's my understanding that employees also went out there to throw trash in the dumpster and to take breaks. And it's certainly possible that employees went out there and did other things as well, but I don't think that matters.
Why not?
Well, just because an employee goes out and sits on the edge of a loading dock and eats a sandwich doesn't make that loading dock a diner. The key thing here is that Chimes used this area as a loading dock. That's what matters.
Thank you, Your Honor. That concludes our reading of this deposition, and we pass the deposition witness.
Any cross-examination?
Yes, Your Honor.
You may proceed.
Picking up on page 6, line 11. Did you inspect the area behind the store where there is a little landing area and some steps?
Yes, I did.
Why did you inspect that area?
At the beginning of every inspection, I asked the representative for the employer to outline for me all the areas where their employees work. When I asked that question to the manager at Chimes that day, they told me that the employees regularly worked in that area behind the store and took smoke breaks there. So once I had that information, I made sure to include it on my list of areas to inspect.
When you went out there, what did you notice about the steps in that landing area?
Well, at first I was a bit alarmed because there were some pretty obvious issues.
Like what?
Well, there were stairs and a landing area, but there were no guardrails anywhere. Plus, the concrete on the edges of those steps and that landing were cracked and eroding away. Someone with half as much experience as me could look at that and see some pretty obvious problems.
Going to page 11, line 16. Did you ever inspect that area behind the store at night?
No, only during the daytime.
Did you notice a light out there when you were doing your inspection?
I did. You'll see it noted in my report.
Did you ask the manager about that light?
I did, like you can see in my report.
And what did the manager say?
The manager told me that they always turn the light on when somebody goes out back at night. So that seemed good enough for me.
Did you have them turn it on for you while you were back there?
It didn't seem necessary.
Thank you, Your Honor. We have no further portions we'd like to read.
Any redirect?
No, Your Honor. And with that, the defense rests.
Would you all like about 2 minutes to get ready for your closing, or are you ready to proceed?
Could we get a time check, Your Honor, and then a break would be great.
Yes, you can. The defense has approximately 17 and a half minutes left. The plaintiff has about 18 minutes left.
Perfect. Thank you, Your Honor. And then, did you say 2 minutes?
Yes, we'll take a very short recess.
Okay, all right. See you soon. Thank you.
All right, council. Make sure all of my jurors are back. Mr. Bernard,
I'm here, Judge.
Ms. McIntyre,
Here, Judge.
and who am I missing? These names are jumping around so fast I can't. Mr. Rowe, are you judging this one?
Yes, I'm here.
All right, then that gives me everyone. All right, then plaintiff, you may proceed.
May it please the court. They failed to fix, failed to inform, and they failed to warn. You heard that while Miss Gilmore was taking her break on that cold, dark winter day on January 23rd, 2019, she went outside to swim. We know that because the defendant failed to maintain the steps Miss Gilmore had to take to get back to work, she fell. She wound up at the hospital without a job, reminding her of that horrible day forever. You now know, members of the jury, that fall could have been prevented, but it wasn't. You heard that the CEO of Chimes department store runs a family business, but they sure don't treat their employees like family. It was clear from the moment that that concrete started to crumble that the steps Chime was sending their employees onto day in and day out were not safe. The people were going to get hurt if they left those steps with its crumbling concrete, no rails, no lights. So when the defendant failed to fix the steps, failed to tell their landlord about the dangers, and failed to warn their employees that it might be dangerous, the defendant did nothing to protect the safety of their workers, did nothing to treat them like family. Because they failed to fix, failed to inform, and failed to warn. That makes the defendant negligent. Now, we had to prove to you by a preponderance of the evidence that the defendant, Chimes department store, was negligent in the way they maintained their property. So that means we had to prove three things were more likely true than not. First, that there was a condition that posed an unreasonable risk of harm, those steps you heard about today. Second, that the defendant knew or should have known about the danger. And third, that the defendant failed to exercise ordinary care to protect Jordan Gilmore from the danger by both failing to adequately warn Jordan Gilmore of the condition and failing to make that condition reasonably safe. And we've proved that to you today. But just to be sure, before you go off to that jury box and deliberate, I want to walk you through how we have proved each of those elements. So let's start with whether the condition posed an unreasonable risk of harm. We learned today from Ms. Gilmore that employees at Chimes were instructed to use the steps every single day as employees, that they had to take out the trash, take breaks, and clean in the area behind the store. Now, to get there, they had to take those steps that were crumbling, members of the jury, and you saw the condition of those steps. You'll get to take Exhibit 2 back with you when you go off to deliberate, but you can see right here that there's no railing on the side of those steps, meaning Miss Gilmore told you she had to steady herself by holding the wall when walking up and down those steps so that she could safely get up and down. Now, you also saw what those steps looked like when the door was propped open. And we saw that in Exhibit 3. Here, you can see that there is only inches of space for a person to be able to walk up if they are propping the door open like Miss Gilmore did. You can also see that loose concrete, members of the jury, that cracked area, the pipe where the railing once was. This is enough, members of the jury, to prove that first element. And that's how we know we have. Because those steps, they did pose a condition that would cause an unreasonable risk of harm. So you can check that off your list right now. So let's move to that second element, whether the defendant knew or should have known about the danger that those steps posed. So Ms. Gilmore testified today. She told you that she didn't just inform the managers at Chimes about the condition of those steps once, but rather she did it twice. Now, the first time she told you that she had complained about the condition of that landing because she was told that she had to smoke there. And the light outside, it never worked when she went out there. So she brought those concerns to a manager at one point, and the manager told her, well, that light switch, it's out of our control. We can't touch it because it's actually in a building that's not ours, that we don't own. So that didn't fix the problem. But then Ms. Gilmore told you that after her accident, she spoke with the manager again. And the manager told her loud and clear, she said, yeah, we probably should have fixed those stairs a long time ago. I talked to the owners about it a few times, but we always have bigger problems to fix than that. I guess, sorry about that. Members of the jury, it's plain and clear. A manager at the defendant's store knew that those steps were broken. She told someone to fix those steps. That's enough to meet that second element, but you heard more evidence, even if that's not enough. You heard on cross-examination from Ms. Geller, the CEO of this store herself, that in fact, there was an accident that occurred on those steps 9 years ago. And you saw the report of this accident where it clearly said that an individual slipped on some loose concrete, had nothing to hold onto because it was dark outside. And then you saw on that last page of that document that the manager of the company at that time, she said that the cause was the failure to have that light fixed, members of the jury, and that it needed to get fixed in order for people to go out there safely. So again, we see 9 years ago, someone knew about those crack steps. We know that at some point during Mrs. Gilmore's employment, someone knew about those steps. And we also know, thanks to an inspection that was performed by one of the managers, that the company was in fact aware of the premise and the condition of that premise. You heard that it was the manager who told that inspector, that OSHA inspector, that there were cracks, that nothing, the light didn't, she lied actually that the light didn't work because she knew that she couldn't control the light from the inside. And she told them that that railing had been ripped out in the past. So we know that even a year before the accident, the defendants knew about it. So that's enough, members of the jury, to prove that second element, to prove that they knew that those steps were dangerous. And that brings us to our final element, to the things I've been repeating over and over throughout today's trial. That the defendant failed to fix, failed to inform, and failed to warn Ms. Gilmore. Now, we know that they failed to fix the landing because Ms. Gilmore, she showed you what those steps looked like on the day of the accident. And you saw Exhibit 3, members of the jury. We're going to bring it up one more time for you. And when you see Exhibit 3 and you take that back with you, you can see clearly that that concrete, it was crumbled. And Miss Geller, the CEO, she told you herself, yeah, that's what those steps looked like before the accident. I was aware of all of that. Now, you also learned that those steps and the light above those steps, they've been broken since at least 2010, when that employee reported the light did not work and that he fell due to some loose concrete. So for 9 years, that's what those steps look like. For 9 years, the defendant did nothing to fix those steps, nothing to fix the light, nothing to fix that crumbling concrete. In fact, you heard that it wasn't until after Miss Gilmore's accident, after someone got hurt using those steps a second time, that the defendant finally added a switch to control the light over the steps. So it wasn't that they couldn't fix it or that their lease preventing them from doing so. It was that they simply didn't want to. That's negligence, members of the jury. But the thing about this defendant is they had other chances, other opportunities to do something, anything, even something that put all the burden on someone else to fix those dangerous steps. But they didn't. They didn't inform their landlord about the issue. Members of the jury, we know that it was possible for them to do that because they've done it before. They did it when they wanted to get that railing removed back in 2005, but they didn't do that when it came to these steps. They didn't send an email, didn't call, didn't do anything. Now, Ms. Geller, she tried to tell you that, no, we don't control that area per that lease that you saw, that map. Even though they made their employees go outside to that area every single day, that somehow it wasn't their responsibility. But you can't just say that when you know the opposite is true. You heard from the CEO herself that her employees frequently use the exit at the back of the store, that they use it to throw out trash, to unload items into the back of the store, to take their smoke breaks. And you saw the specific company policy that requires them to take those steps out there and smoke in the back entrance. It clearly states here, members of the jury, and you can read it again when you go back to deliberate, that if you're going to smoke, you need to do it outside behind the store where our dumpster is. Now, the only way to get there is to take those crumbling steps without a railing and without a proper light at night. They also ask their employees in this memo to clean up the area near the dumpster so that they can, and I quote, members of the jury, keep our area clean and presentable. Our area. So when the defense gets up here and tries to explain away how they don't have control, remember this memo. But they can't just say that to you, members of the jury, when you know the opposite is true. Remember, using those dangerous steps was not a choice for the defendant's employees. It was a requirement, a rule that those employees had to put themselves at risk. And the defendant couldn't even bother to fix it, or at least inform the landlord of the dangers. Don't let your common sense walk out the door. The least the defendant could have done was warn their employees that the steps that they were forcing them to take every day were dangerous. To watch out for that crumbling concrete, to shine a flashlight, or simply avoid using that exit when it was dark. It was that simple. But we heard that there was no sign, no reflective tape, no safety policy, nothing that alerted their employees that those steps might be dangerous. Ms. Gilmore told you that herself. They failed to warn. And because of that, We know we've proven that final element, members of the jury. So when you go back to that jury room to deliberate, and when you see this form that asks you if the negligence of Chimes caused Miss Gilmore's injury, the answer is easy. You know you can answer yes. If anything has been clear throughout today's trial, you know that it was this defendant's failure to fix, failure to inform, and failure to warn that caused Miss Gilmore's injuries. It's this defendant that's responsible for Miss Gilmore's injuries. Find Chimes Department Store liable. Thank you for your time.
Defense.
Yes, Your Honor. May it please the court. Your Honor, Ms. Plasecki, and good afternoon, members of the jury. Throughout this trial today, Ms. Plasecki told you that Chimes is solely responsible for Miss Gilmore's accident. But the evidence has shown you that there was 2 other parties responsible for Miss Gilmore's accident. Kermit Realty Group, as the corporation that owns, controls, and maintains the loading dock area, and the plaintiff for what she did or did not do. Members of the jury, you are now being tasked with deciding who was ultimately responsible for what happened. Whether it was the landlord's failures, Miss Gilmore's own conduct, or, and as the plaintiff has claimed, Chimes Department Store. But when you go back and consider their claims, Judge Harris is going to tell you that you can assess liability against all 3 of those people, not just Chimes Department Store, as the plaintiff counsel just tried to tell you. You don't only have to mark yes on just one of those. There will actually be 3 options on this jury charge, not just the one that she showed you. And the plaintiff has claimed that only Chimes is responsible for the plaintiff's accident. But they have failed to prove their claim by a preponderance of the evidence because Chimes acted reasonably and responsibly. But the actions of the landlord and the plaintiff caused this accident. Now today, you heard from the plaintiff herself about her involvement in the accident. She told you that out of 10,000 times of going out to the back door, only once did she have a problem. In those 10,000 times before January 23rd, 2019, she never tripped, never slipped, never fell, or even had any sort of problem with the lighting, the concrete, or the stairs. Now, Ms. Plasecki told you that this case was about 3 things. She told you that they were about fix, inform, and warn. Let's talk about each of those. So where do we see a lack of informing? Well, the simple answer is we don't. Because the plaintiff had been out on that loading dock thousands and thousands of times. You heard her tell us that she was familiar with the loading dock. In fact, we heard her say that it was a pretty regular occurrence that the lights on that loading dock were not on. Yet she didn't bring her phone out there with her to use as a flashlight. And the only light source that she chose to use that night was the light coming through the one doorway with a coworker standing directly in front of it. Now, this door was not the only door that she could have gotten light from. We saw today that there were 2 doors that could have been opened so that she could see better, or even asked for that other door to be open so that way she could have a safe route back to the store. Members of the jury, there were multiple options and paths that the plaintiff had to get back into that store safely. We heard that the door was only open halfway, not as it's shown in this picture, but halfway. We heard that the door could be open completely flush to the wall, as we are seeing here. We can see in this photo that that other door can open. And if that other door was open, Miss Gilmore would have had a completely clear path through that door up the steps. But the plaintiff chose to have only one door open. You heard her agree that she never asked for the other door to be open, never asked for the door to be moved out of her way or open completely flush to the wall as we see here. Instead, she chose to go up and around the half open door. Now, the plaintiff also told us that there was no guardrail around the loading dock. And she knew that. And she agreed that that was reasonable because, in her own words, how could you put a railing on a loading dock? Now, Reese Geller also testified today, and she told us that they would use that loading dock every single day since they got the building. Now, Ms. Plasecki came up here and made a big deal about how the Chimes department store uses that loading dock every single day. But members of the jury, let's look at the numbers here. Chimes department store is using that door, using that loading dock, using those stairs every single day, multiple times a day for the last 15 years. And they've had 2 incidents, 2 in the last 15 years, with multiple employees going out there tens of thousands times a day. Now, Ms. Geller also told us that there were certain areas that Chimes department store were not responsible for, that the lease that they signed stated that they were under the control of the landlord, Kermit Realty Company. This included the loading dock, because as under their lease, and to the best of Ms. Geller's knowledge, that was a common area. And we learned today that common areas are the responsibility of the landlord, not Chimes department store. Now, you heard from the deposition of Miss Kelly Danes that she admitted that this area was used as a loading dock. And then you heard her admit that she doesn't know of any regulations that apply to a loading dock. Members of the jury, the plaintiff's own expert told you that she doesn't know of any regulations that apply to this store, any regulations that apply to the loading dock. If she doesn't know the regulations, how can she tell you that they broke them? Now, who did tell you about the regulations and who did explain those regulations was Perry Hayden, an OSHA inspector who went out and physically inspected the Chimes department store. And when she went out to that store, she told you that Chimes complied with every regulation. She told you that there wasn't a guardrail, but there didn't need to be. Now, she didn't just say that. She didn't come up with the fact that a guardrail didn't need to be used out of thin air. She told you that OSHA said so, that OSHA has regulations that state that a guardrail is not needed on a loading dock, and it's detailed in this report that we saw here today. Members of the jury, the bottom line is this, that the law was complied with. Every single law pertaining to loading docks was complied with. So as for Ms. Plasecki's point about fixing, what was there to fix? Nothing. Chimes was required to comply with the law in their lease. They were required to comply with every OSHA regulation. And you heard that they complied with each and every regulation. What is there to fix when the OSHA inspectors, the authority on safety for buildings, tells you that you have a clean bill of health? Why fix what's not broken? Finally, members of the jury, Ms. Plasecki told you that this case was about warning. This is very simple. The plaintiff knew of those conditions outside the door. She was out there every single day, every single shift for 10 years. What do OSHA regulations tell us? That employees have to be responsible for their own actions. Now, Ms. Plasecki wants to say that a sign or reflective tape would help. Members of the jury, a sign or a reflective tape can't necessarily say that that would have prevented an accident, because the landlord did not maintain the areas he was in control of under the lease. And because the concrete was not well maintained, which potentially caused the plaintiff to slip. But the plaintiff had other options on where to take her smoke break. The plaintiff had other options on what light source to use. The plaintiff had other options on what door would be open. The plaintiff chose to take his smoke break down by the dumpster instead of up on the loading dock with her coworker. The plaintiff chose to only use the light coming through one door rather than two. The plaintiff chose to have the only door open that would block her path, instead of having a door open that would completely clear the path, and she would have wide range of that landing area. Members of the jury, that is what actually happened on January 23rd, 2019. An accident caused by a series of mistakes and a series of risks taken and a series of failures made by the landlord. And because of that, we ask that you deliver a verdict established by the law and supported by the facts. A verdict finding Chimes Department Store not fully liable. Thank you.
Plaintiff,
Yes, Your Honor.
any rebuttal?
Yes, Your Honor. May it please the court?
Proceed.
Defense counsel just got up here and told you the Chimes Department Store isn't liable because the accident was a result of Miss Gilmore's choices. But members of the jury, when accidents are brought on by unsafe work conditions, when a family business can't treat its employees like family, that makes them negligent. Defense counsel expects Ms. Gilmore to have to jump through hoops to ensure that she could get enough light, when it turns out that all along, the defendant was able to install a switch to turn that light on. It was that simple. But for 9 years, it was the defendant's choice to wait to fix that light. It was the defendant's choice to rip out that railing. It was the defendant's choice to leave that concrete crumbling. And it was the defendant's choice to not inform the landlord for 9 years, to never send an email, never call. So when defense counsel has the audacity to ask you what was there to fix, remember this picture. An accident would have never occurred right here on these steps if there was something to grab onto, if there was no loose concrete, no exposed pipe, and if that light had been fixed the moment they signed that lease. Members of the jury, one accident is one accident too many. It doesn't matter how many accidents happened on those steps. What matters is that Chimes Department Store, they failed to fix, they failed to inform, and they failed to warn. Find them liable. Thank you.
All right, counsel, we will get our ballots ready and we will take those down and give us just a couple of minutes. While those are being tabulated, we'll come back and give you some critiques. Give us just a moment. Okay, hopefully in a minute or two, we'll get some feedback that tells us our ballots added up and that everything has come to fruition. This is our 12th and Top Gun competition. I've been fortunate enough, and a few other scoring judges want to join me on camera. I've been fortunate enough to be a part of all 12 of them. And we even had a situation a couple of 3 years ago, maybe 4 or 5 now. I can't recall which now, but we realized on Saturday night we had a tie between 2 folks, and we tried hard to get them to flip a coin, and they didn't want to do that. And so I started yet another round at about 7 o'clock that night. When everyone else went to dinner, there were a handful of us stayed and went through a round we hadn't counted on. So we've added enough tiebreakers to hope that that does not happen again. So in a few minutes, we'll hear if we did our part correctly. One of the things I wanted to address with you, because it's a pet peeve of mine, and both of you did it, started out with the defense side doing it more than the plaintiffs, but ultimately both of you addressed the other one, what I call personally, in that you would say, well, Miss So-and-so told you, or Miss So-and-so told you this, or avoid that. We are professional people in a profession that is one of the few that is truly recognized as such. And in so doing, what that means is we can disagree without being disagreeable. And I think it's very important for the profession for us to be seen as such. So all you have to say is the plaintiff tells you or the defendant tells you, but you don't need to use the other counsel's name when doing so. That is an argument on behalf of their client, not necessarily their own. And so don't make it personal. You'll get involved with the trial at some point that is so, the other side is such a jerk, you need to do that just to let the jury know you don't like them either. But this is not the time or place. Couple of issues, plaintiff, I would be a little careful with the crumbling concrete argument. I understand it's kind of what you got, but to hear the way it sounds, it almost reminds me of one of these mountainsides with shale on it that's going to fall away. And any of us who've done work around concrete, which unfortunately I have, even though it may have some cracks in it, most of the time it's not going anywhere. And when you look at, in fact, the old saying is it does 3 things. It turns gray, it gets hard, and it cracks. And when you look at those, what you see is some sloughing off, but you can see that it's weathered underneath that to the point it's not going anywhere. And none of the photos show any pieces of concrete laying around near the base of it. So it looks like it's broken as far as it's going to break. And if you get somebody on that jury, which in Texas you likely will, who's a construction worker, they're going to say, that's not the problem. That might be that they slipped off that edge, but it's not crumbling and cracking and falling apart. From the defense standpoint, I thought you were way too critical of what this lady should have maybe done to protect herself. Maybe be a little more compassionate if you really think it's a responsible third party. Now, if I was going to do it in such a way, I would probably talk about, well, she should have taken her iPhone or a flashlight. I would have probably pointed out smoking is not a required part of her work. Those other things that she may have gone out there to do were. But when someone is going off to do their recreation that their boss is good enough to let them do, particularly a recreation not even good for your health, then I might say, ladies and gentlemen, we'd be hearing a different story if she had fallen, taken 2 heavy bags of trash out. But this was a situation where she went to do something that was her recreation or whatever you want to call it. And at some point during that time period, it became her duty to take on some protection of herself, things of that nature. Why don't we start with the others who were here judging, and then let you all have some quick input. Don't everybody jump at once.
Sure, I'll start out, Judge.
Bernard.
They were very specific with us to try to give you guys just sort of one comment each, not only for timing, but also not to overwhelm you.
Yes.
Judge, you've done this, I think you said 12 years. I might be a close second place. I'm either at 10 or 11. I've got to go back and look at it, but I'm so impressed every year. I thought you both just did a really nice job. You both have a really nice demeanor about yourselves. You both have a very pleasant, just sort of general delivery style. And I think that sometimes, especially as a woman, can be difficult, right? You've got to strike a balance, and I think you both have it. So, good job on the way that you present yourselves. Okay, plaintiff, Ms. Pisecki. So my comment for you is, you spoke to us in a way and this is specific to your closing, although you did a little in opening, as though we had to reach the same conclusion that you did. And so you used words like clearly and, that you must conclude, things like that. And I guess my advice to you on that way of delivering your message is that if you have jurors that aren't with you, telling them that they're with you makes them really not with you, right? So the way that I think I would go about that if I were you is I would instead refer to like the facts or the evidence, right? So instead of saying that you have to decide this or clearly, the conclusion is clearly such and such, I would say the evidence establishes, or the facts, the undisputed facts showed. Right. So you're not telling me what I think, you're telling me what the facts are telling me. And it's a little less personal in that regard. So that's my one piece of advice for you. Ms. Jeffries, what Judge Harris said is exactly what I was going to say to you. You talked a lot about plaintiff's counsel in your closing by name. And I think what the judge said is spot on. Another technique that I would use if I were you, or that I have used in that situation, is I would refer to like them, or you heard a lot about such and such, or they told you such and such, as opposed to, Mrs. Plaintiff's lawyer said this. So it's less personal. You're really focused on the facts. So those are my two pieces of feedback. I do have a substantive question though, because we don't have information from your packet. Are you told anything about in these jury charges, are you told anything about the idea that an employer, at least in Texas, has a non-delegable duty to provide the employees a safe workplace? Is there anything in your packet about that or in your jury charge about that?
Yeah, we've told them just to forget all about Texas workers' comp law.
Yeah, but is there an indication in the charge or in your materials about a non-delegable duty for an employer to provide a safe workplace?
No.
There's not. Okay. All right. Well, then I have nothing to add on that. So anyway, but great job, both of you. Really, really fantastic work.
I can go next briefly. Yeah, great job to echo what everyone has said. I guess for the one comment deal for plaintiff, I think you presented well. You obviously handled your opening and closing well. One of the things I would recommend though is obviously when you hear the defense's theme is going to focus on contrib, right? Get out front in those bad facts, right? Like, your client is going out there every single time they work. So get them to explain why this specific time was different, right? So as opposed to when they start getting cross-examined and they're having to give their reasons and kind of backpedal, you've already gotten their story out up front before defense has even had a chance to cross-examine them. For defense, again, great job. You were able to adapt and handle some issues that came up. But one of the things I thought was, with your opening, get your theme up front. You really didn't give the theme, like safety is a two-way street, till the end. Give that up front and then build upon it as you move on. And then with your closing, so I do defense work, and there's always this hard balance when you're making a contrib argument and then you have another third party that you're trying to blame, right? So that's a difficult situation to be in. But the one thing that I think, does your charge lay out where the jurors are going to put percentages?
Yes, it does.
Put that up. Give the jury guidance on how they should put it. Because one of the things that is hard to deal with when you have bad facts on the defense side is you want to keep your credibility. So you don't want to ignore the bad facts and not address them. But when you closed out your closing, you said jurors find the defendant not fully liable, right? So you're putting in there, like, give us some liability, right? But if you're going to do that, which you have to do in some cases, sometimes you gotta eat that liability. Give them guidance. Say, give us 10%, but look at third party here. Look at the plaintiff's actions, and so they're not just going back there and guessing and being like, well, she said don't find them fully liable, so let's give them 90%. And then that's a hard hit to your client. But it's a difficult line to walk when you're doing this defense work. But great job to both of y'all.
I'll go next. Can y'all hear me?
Yes.
I'm sorry, I had to turn my camera off. My internet connection is not strong enough to have both on. Y'all both did a great job. I think you both have a great presence and great, you use your voice really well. Two things. Defendant, during pretrial, Judge Harris asked you to be brief, and you were not very brief. You went on for about 2 minutes. So work on that, work on brevity. And plaintiff, I actually have the same comment for you. I think your closing went on a little too long. And I think your rebuttal also went on a little too long. So, when they go on longer than they need to, you kind of lose your point a little bit. But other than that, I think y'all both did a great job, and I wish you the best of luck.
Let me give you, because I had the numbers going, your closing argument was almost 1/3 of the entire time you spent. And that's too much. That's overkill. Okay.
Hey guys, I'll be really quick because I'm last and I know you probably want to get out of here. But I thought you both did a great job. Oh, I'm Maria. I work in Austin as a commercial litigation associate. I do a little bit of plaintiff work and a little bit on the defense side. So I'm going to start off with plaintiff. During your opening, you ended with find them liable, and you also did this with closing. I know this is a stylistic thing. I prefer people to end on their theme. I think it's just stronger. And I think that it would have sounded stronger if you included your theme at the end with the failed to fix, inform, and warn. I think you did a great job in opening, kind of like peppering that in where it wasn't too much and overwhelm the jury, but like we got it across and it was great. Also with the closing, I love the little chat bubble exhibit you pulled up. I thought that was really good. With defense, on your cross-examination of the plaintiff, you had her agree to the 10,000 steps or the 10,000 times that she's been up and down these stairs. That is such a powerful fact. I think you should put that in your opening. I think you should say it a bunch of times. I mean, this person has gone up and down these steps 10,000 times. That is an insane amount. And I think that's something that you need to just kind of push with the jury a little bit more and get that number in their head and repeat it over again in closing. Then with your direct examination, your witness kind of messed up a little bit with the OSHA inspection, and that's perfectly fine. No one holds that against you. Just don't let your face show it. So, and I do the same thing. You can see it the moment that it happens and you're like, oh no. Just make sure that you just keep a calm face, know that the jury's always watching you, and then just gently remind the witness, which is exactly what you did after, and you did a great job. So it's mostly just freezing your face at first. Yep, And then the only other thing I had was for closing, everything that Cameron said with the ending. I really think you just need to kind of work on that and tweak it a little bit more. And then I think you did an incredible job responding to the plaintiff and using her theme throughout your closing too. I thought that was an incredible job. That's it.
I get the thumbs up. So our ballots came out good. So thank you to the other folks who helped judge. I guess I kind of forgot to introduce myself. My name is Lee Harris. I'm an adjunct in the practice court program here. I think I'm in my 23rd PC class right now. And I've spent 16 years on the state court bench at this point, and don't really see any end in sight. So anyway, I probably bring a little different approach to the role of judge, because this is what I do all day, every day, and I don't have the most patience in the world like people who play judge on a contest. So to a certain extent, you got the real McCoy today. All right, you all will be getting some word from the folks here at competition on where you stand, what's going on, and be ready for your 3 o'clock rounds.
Awesome. Thank you so much, everyone.
Thank you for your time and good job, Paulina.
Good luck,
You too.
guys.
It was so much fun. Thanks, everyone. Bye.
Thank you.
Bye.
Hi, Your Honor, I just want to confirm that everybody can see and hear me.
We can. I'm going to run through everybody who's here and make sure we can see and hear everybody in just a few minutes. I'm letting people in the room and checking them off right now.
Got it. Thank you so much. I appreciate that, Your Honor.
Very well. As of right now, I think we are only missing both the witnesses for the defense. I'm going to go ahead and check in my scoring judges. So Will King, can you hear and see us? Good.
I can.
All right, sounds good. Ronnie Turner, hear and see us?
Yes, Your Honor.
Christy Hicks, hear and see us?
Yes.
All right, thank you, ma'am. And Cody Hill.
I'm here. Thank you.
All right. And are you Tyler or Marina that already said you could hear or see me? Your name's Tyler, right?
I am Tyler. Yes, Your Honor.
And Marina, can you hear and see us? Sounds good. Josh, can you hear and see us?
Yes, Your Honor.
And Jackson.
Yes, I can, Your Honor.
Very well. So we are still waiting on the two witnesses for both teams. And then as soon as they get here, we'll go ahead and get started.
Witnesses are here, Your Honor.
Are y'all not on separate computers?
We just have one computer between the two of us.
So we've got Nico, is it Nico?
Nico. Yeah.
Nico and Christian?
Yes, he's here too.
All right, then we're going to take just a few short minutes and we'll get started right at 3 o'clock.
Ronnie Turner, how are you?
How are you doing, Mr. King?
Just living the dream.
Yep. Ain't that what we all doing?
There you go. How's your kiddo doing?
Good. She's I say good, but she's extremely sweet sometimes, but she's extremely sour sometimes.
I'm about to find out.
Really?
Yeah.
When? Oh my God! Congratulations, man.
It's crazy. I got to go home after this and paint the nursery.
You know what it is?
Yeah, girl.
Okay, man. Congratulations, man. It's great. Yeah.
About time.
Man, yeah, I love that little girl, man. She's something else. She's curious. She's always looking around. She's always trying to figure out something, grab a hold of something. If you sit on your desk, she's gonna knock down whatever's on your desk immediately. That's her first response.
Oh man. I hear they're very tiring for the first couple weeks.
Yeah, man, be prepared.
Yeah.
Be prepared. Mm-hmm.
I just got a bunch of hearings and trials continued, so I think I'm
That's
all
good.
right. Yeah.
In Houston, most of them?
Yeah, most of them in Houston.
All right.
All right, we are just about ready to get started. Before I call the case, my name is Bailey Strohmeyer. I have put my cell phone number in the chat. So parties, judges, witnesses, if you have any problems, write it down right now so that you have it if you get kicked out of the room. And if you have Zoom issues, connectivity issues, give me a call. We'll pause the trial. We'll get it straightened out. We have 55 minutes to try this case today. I will be keeping time and we will be sticking strictly to those time limits. I'll give you a time check at the end of plaintiff's case. And we'll take a short break at the halfway point as well at that time. If you need a break at any other time, let me know and we'll take that up. All right, I'm gonna make sure everyone is here one last time. Looks like I have all of my counsel. Ronnie, if you would go ahead and turn your camera off. I've got all of my scoring judges in the room with their cameras off. And with that, we will get started. This is cause number TGCV001-21, Gilmore versus Chimes Department Stores. Are the parties here and ready to proceed?
Yes, Your Honor. Would you like our
Yes,
formal introductions for the record?
Yes, please.
Good afternoon, Your Honor. My name is Tyler Jeffries. My last name is spelled on the screen, but it is spelled Jeffferyes. And I, along with my co-counsel, Marina DeRosa, represent the plaintiff, Jordan Gilmore, in this matter here today. Your Honor, following opposing counsel's introductions, may you return to us to address some housekeeping matters?
We will take up housekeeping matters from both parties after the defense counsel introduces themselves, and then any pretrial issues that need to be taken up after housekeeping is addressed.
Thank you, Your Honor.
Defense?
Good afternoon, Your Honor. My name is Joshua White. I, along with my co-counsel Jackson Haddon, represent the defense in this case, Chimes Department Store. We have no substantive motions, but when Your Honor is ready, we do have a non-substantive matter we'd like to address with the court.
Okay, we will take up the non-substantive housekeeping matters first. Miss Jeffries, you can proceed with your housekeeping matters.
Thank you, Your Honor. May we assume that all witnesses have been sworn before testifying today?
You may.
These exhibits have been pre-marked numerically. May these exhibits retain their original markings?
Yes, they may.
If the court would like to hear arguments on objections, would you like us to preface those arguments with assuming we're outside the presence of the jury?
If it's an argument that needs to be held outside the presence of the jury, yes, we're not going to constructively assume that all arguments are outside the presence of the jury.
Understood, Your Honor. Would the court like us to proffer experts before receiving their expert opinions pursuant to Rule 702? For Your Honor's information, we are calling experts via this deposition this afternoon.
Yes, I would.
And then, Your Honor, when laying foundation for exhibits, may we share those exhibits to the screen, or would you like us to just invite the court and the witness's attention to the exhibit file?
You can share them. What we'll do is it'll be constructively before the court until it is offered and accepted into evidence. At that point in time, when it is admitted and any objections are ruled on, you can then ask to publish it to the jury. For the purpose of Zoom, while you're proving it up, you can show it to us before it's admitted.
Understood, Your Honor.
Does that make sense to both parties? Very well.
After exhibits have been admitted, but maybe share those exhibits to the screen, or would you like us to ask for permission every time?
Once an exhibit has been admitted, you may share it without asking again.
Thank you, Your Honor. And then when impeaching or refreshing recollection, may we post the witness's deposition to the screen for the ease of the witness and Your Honor?
Yes, you may.
And finally, may we have the correct pronunciation of Your Honor's last name?
Strohmeyer.
Strohmeyer. Thank you, Your Honor. With that, we do have some stipulated matters to address before the court, but those are substantive.
Let me take up the defense housekeeping issue first, and then we'll move on to substantive issues. Mr. White.
Yes, Your Honor. So this isn't so much a housekeeping, but it is a stipulation that opposing counsel and I were able to meet or come to a meeting of the minds on during our pretrial conference.
Okay.
Your Honor, this is regarding Exhibit 14, which can be found on page 164 of the record. Today, the plaintiff, Jordan Gilmore, alleges that he suffered an accident, which was the result of negligence on the part of my client, a Chimes department store. There's a report of an incident 9 years prior where an employee alleged falling in the area at issue in this case. Opposing counsel and myself have agreed to pre-admit this exhibit with the stipulation that opposing counsel will not be arguing the contents of this exhibit for the truth of the matter asserted.
Ms. Jeffries, does that reflect your understanding of your agreement?
Yes, Your Honor. And in the interest of full disclosure, when speaking to opposing counsel, we did disclose that we will be using this exhibit and having the witness read from it, but we will not be arguing the truth, just that they were notified of the statements that were made.
Okay, very well.
Your Honor, that concludes all of the motions or matters that defense has today.
Very well. Ms. Jeffries, I think you had something you wanted to talk about as well.
Yes, Your Honor. We have a number of other exhibits that we did stipulate to their admissibility that we would like to admit at this time. Would you like me to list those out now?
Yes, please.
So those would be exhibits 1 through 4, exhibits 6 and 7, exhibits 11 and 12, exhibit 17 and exhibit 19, as well as exhibit 14, which Your Honor just received.
Very well. Mr. White, does that accurately reflect your understanding?
Yes, Your Honor.
Okay, then we have exhibits 1 through 4, 6, 7, 11, 12, 17, and 19 admitted. Anything else, Ms. Jeffries?
Yes, Your Honor. We ask that the court take judicial notice of a couple of statutes. These statutes will be, would you like me to post them to the screen or just read off the citations?
If you would just read off the citations, that'll be good.
Yes, Your Honor. Those will be OSHA regulation 1910.23, specifically section D1, OSHA regulation 1910.24, section H, OSHA regulation 1910.37, B as in boy 1, International Building Code 1006.1, and International Building Code 1005.2.
Any objection from the defense?
No, Your Honor.
Very well. The court will take judicial notice of the 5 statutes previously recognized and stated by plaintiff's counsel.
Thank you, Your Honor. With that, we are ready to proceed to opening statements.
Very well. Plaintiff, you may proceed with your opening statement when you're ready.
May it please the court. Your Honor, opposing counsel, good afternoon, members of the jury. Safety first. We've all heard the phrase safety first. We've heard that phrase again and again over the years because those words are important to remember, important to follow, and important to live by, because safety should come first in the home, in the school, and in the workplace. But unfortunately, when it comes to some people, some businesses, and some employers like the Chimes department store, safety doesn't come first. Protecting employees doesn't come first. Doing the right thing doesn't come first. In fact, doing it the easy way is the only way that Chimes does business. And it's because of this that one of their most dedicated employees paid the price. His name is Jordan Gilmore. And on January 23rd, 2019, he suffered serious injuries because of Chimes's negligent conduct and complete indifference to Jordan's safety. Now, today, members of the jury, you have to decide if the defendant should be held responsible for their negligent conduct, or if they should just get away with it. In order to make that decision, you'll have the testimony of witnesses, the evidence presented, and the instructions given to you by Judge Strohmeyer, who will tell you that the defendant department store has a duty to provide their employees with a safe place to work, to provide them with protections and precautions to ensure that each of their employees are safe. And today we will prove by a greater weight of the evidence, or more likely than not, that the defendant breached that duty because the defendant department store failed to follow minimum guidelines and let safety fall through the cracks. And before I talk about that in more detail, I would like to introduce you to Jordan Gilmore. Mr. Gilmore, would you please turn your camera on? Thank you. This is Jordan Gilmore. He was born and raised right here in Waco, Texas, and is an avid churchgoer, participates in Sunday school as well as Wednesday book club. He worked at Chimes department store for over 10 years, dedicating his career to working at this department store as a cashier. Thank you, Jordan. You can turn your camera off. Now you'll learn that before Jordan Gilmore came to work at Chimes department store, many years ago, the defendant moved into a building located in a mall and decided that they wanted some construction done. In fact, we will hear that the defendant directed the landlord to construct a concrete loading dock in the rear of the building by removing a safety railing right outside of an emergency door, which violated various safety codes. But that wasn't the only unsafe condition. You'll learn that the concrete on the loading dock itself and the stairs leading to that loading dock became worn after years and years of use. And those stairs began to crumble. In fact, the concrete became so worn, so hazardous, so unsafe that it was only a matter of time before someone was injured. Now, this was not unknown to the defendant. You will hear that the defendant knew of these dangerous conditions, that he saw it for himself. And what did the defendant do after learning of this dangerous condition? In a word, nothing. They didn't repair the concrete platform. They didn't repair the concrete stairs. They didn't put back up any type of safety railing. They didn't even put up a sign warning employees of that dangerous condition that they knew about. And not only that, but we will learn that the defendant was specifically told that additional lighting was needed in that area. And again, what did the defendant do after learning that? Nothing. They didn't put up additional lighting. They didn't repair the one light that they had out there. They didn't do anything to make that area safe. Instead, the defendant directed their employees to work and take breaks in that loading dock. In fact, you'll see a memo today that the defendant sent to their employees, directing them to only use the loading dock area for their smoke breaks, that this is the only area that they should be at, which is the entire reason why Mr. Gilmore was in that area on January 23rd, 2019. Mr. Gilmore will take the stand today. And he will tell us that he went out on that loading dock to take a short break. And unfortunately, because of the poor lighting condition, the poor condition the steps were in, And because the defendant ignored those hazards and let safety fall through the cracks, Jordan fell onto the hard surface below, where he suffered serious and permanent injuries. Injuries that could have been avoided, that should have been avoided, had the defendant only protected Jordan from the danger by putting safety first. Instead of putting Jordan in danger, they could have put safety first. The defendant failed to do that, which is why the end of this case, after you've heard all the testimony from witnesses and seen all the evidence, I will come before you and ask you to return the only verdict based on the law and the facts. A verdict finding the defendant corporation liable. Thank you.
Thank you, Ms. Jeffries. Mr. White, you can proceed with opening statement whenever you're ready.
The landlord's property, the landlord's stairway, the landlord's responsibility. My client, Chimes Department Store, is a family-owned business. They rented out space for its store from Kermit Realty. As the landlord, Kermit signed a lease, promising that it would maintain its property in a good and safe condition. On January 23rd, 2019, the plaintiff slipped on the landlord's property while walking up the landlord's stairway, and as a result, the plaintiff's injury is the landlord's responsibility. My name is Joshua White. Along with my co-counsel, Jackson Haddon, we represent the defense in this case, Chimes Department Store. They're a department store based right here in Waco, Texas. You may have heard of them or even shopped in their store, but it wouldn't be all too surprising if you haven't. They're not some massive corporation or a chain store. They're a family-run business owned by Reese Geller, a business that's been in their family for 3 generations. Now, while Reese Geller has the privilege of being able to employ local residents right here in Waco, he never imagined he'd find himself defending his company against an ex-employee. Now, during their opening arguments, opposing counsel introduced their client, Jordan Gilmore, to you. Jordan was a cashier at Chimes for nearly 10 years. And I want to make it clear from the start, my client has nothing negative to say about Jordan Gilmore. Before January 23rd, 2019, the only notable thing about Jordan was that he did his job. He woke up and came to work consistently for 10 years. Now, that's important to note, as the evidence will show that in the 10 years leading up to Mr. Gilmore's fall, he hadn't reported any other safety issues. So what happened on January 23rd, 2019 was an unfortunate but isolated event. Now, because the plaintiff alleges that negligence on the part of Chimes Department Store is the reason for Mr. Gilmore's accident, they've got to show a few things, the specifics of which you'll hear a lot more about in closing arguments. But what I want you to remember and really consider during the course of this trial is that for negligence to exist, someone must be found responsible for maintaining safe conditions in the area where the accident happened. The evidence will show that someone was responsible for maintaining that area. Someone was responsible for ensuring the safe conditions of that area. And the evidence will show that that responsible party wasn't my client. Now, you're going to hear a lot about the loading area where Mr. Gilmore fell, and I want to show you what that area looked like. Throughout the course of this trial, it's important to resist the temptation of allowing the details of the incident to surpass the reality of the actual circumstances. The platform Mr. Gilmore unfortunately fell from wasn't at the top of some massive hill. It wasn't from a second story or a roof. He fell while walking up what you see is about 5 steps. Now, at no point will I ask you to belittle or diminish the severity of what happened. Only Mr. Gilmore knows how embarrassing and how uncomfortable that experience was. and it never should have happened. But the danger and the risk involved was minimal, and Chimes Department Store was not responsible for keeping this area safe. The evidence will show that an agreement had been made between Chimes Department Store and their landlord. In exchange for money paid in the form of rent, the landlord of this property, Kermit Realty, would take on the responsibility of maintaining all of the common areas. The evidence will show that their agreement specified that loading areas are in fact common areas. Today, when Reese Geller takes the stand, he's going to explain this agreement a bit more carefully to you. And he's the perfect person to explain because he actually helped negotiate the agreement. Unfortunately, today the other party to that agreement won't be taking the stand. They won't be answering the difficult questions that need to be answered. They won't be taking responsibility. So it's our job as the defendant to explain for us and explain for them. Because today, the only person who is here and able to respond to the legitimate concerns of Jordan Gilmore is Chimes. We just ask that you approach this case, approach Mr. Gilmore's accident, and approach Kermit Realty's failures with an open mind. At the end of this trial, I'm going to ask you to return a verdict of not liable. I'm going to ask for you to return that verdict after you've heard all of the facts, after you've heard all of the evidence. You'll be able to look at the plaintiff's case and look at ours and make that clear finding of no liability on the part of Chimes. Not because what happened to Mr. Gilmore was okay, not because it was his fault, not because there's no avenue to justice, but because justice is fair. It's specific and it's precise. The accident you're about to hear testimony on happened on the landlord's property, took place on the landlord's stairway, and was the landlord's responsibility.
Thank you, Mr. White. Ms. Jeffries, call your first witness.
Yes, Your Honor, the plaintiff calls Jordan Gilmore. Good afternoon. Please introduce yourself to the jury.
Hi, my name is Jordan Gilmore.
How old are you, Mr. Gilmore?
I'm 48 years old.
And where do you live?
I live here in Waco, Texas.
Are you from Waco?
I am.
And are you active in this community at all?
Yeah, I'm pretty active in my church, 7th and James Baptist Church.
Objection, Your Honor. May we be heard outside of the presence of the jury?
You may.
Your Honor, under Federal Rule of Evidence 610, religious beliefs or opinions are not admissible to attack or support the credibility of a witness. So I would just ask that any mention of Mr. Gilmore's religious affiliation not be used to try to garner credibility with the jury.
Response, Ms. Jeffries?
Yes, Your Honor, we're not using this to bolster his credibility. We're simply using it as background information to understand what Mr. Gilmore does in this community and the activities that he participates in.
I'm going to overrule the objection for now. If you feel as though they are using this activity to bolster their credibility again and it gets too far into that, feel free to renew your objection.
Yes, Your Honor.
Yep. Mr. Gilmore, you were telling us how you're active in the community. How are you active here?
I'm active in my Sunday school class at 7th and James Baptist Church. And there's also a Wednesday night book club connected to that group. And about once or twice a month, I'll have some friends from my Sunday school class over to play cards at my house.
And now, other than your activities at the church, do you work at all?
No, I'm not currently employed.
Where did you used to work? Excuse me.
I was previously employed with Chimes.
And is your employment with Chimes the reason you're here today?
Yes, it is.
How so?
Well, one day when I was working, I fell and injured my leg. And so this suit is a response to that injury.
And do you remember what day it was that you fell?
January 23rd, 2019.
What time did you start your shift that day?
I was on the closing shift, so that would have been around noon when I started.
And what time would you have ended that shift?
That shift ended at 8 o'clock.
And what do you do while working?
I was a cashier to help people check out with their purchases.
And leading up to the fall, what were you doing?
Well, at that point in time, I was outside taking a smoke break.
Why did you go outside for a smoke break?
I mean, I've been smoking for a while, so I just not allowed to take a smoke break inside the store. Of course, I had to go outside for that.
Now, when you say outside, are you referring to the front of the store or the back of the store?
The back of the store.
And did anybody tell you that you were supposed to go to the back of the store?
Yes, we were required by management to take our smoke breaks out behind the store.
And how did management tell you this?
At one point in time, they distributed a memo to us employees informing us that's if we were going to take a smoke break on the premises, that's where we're going to have to go, out back.
Would you recognize that memo if I showed you a copy of it today?
I'm sure I would.
Mr. Rosa, would you post Exhibit 1, which has already been admitted into evidence? Thank you. Mr. Gilmore, can you see that?
I can.
And what date was this memo sent out?
It says July 1st, 2015.
And on January 3rd, 2018, had you received any other memo concerning where you could smoke?
No, I don't remember any memo after this one.
And where does this memo tell you that you should go smoke?
I believe it says to go out to the back of the store. I don't know if it was in the first or second paragraph, but if you take a smoke break, to go out by the dumpsters out back.
Thank you, Mr. Rosa. You can take that down. Now, when you went out to back to take a smoke break, was anybody with you?
One of my coworkers, Riley Huntsberger.
What time was it that you and Riley went out back?
I think it was around 7 o'clock that night.
What was the lighting outside like at that time?
Well, that time of the year, the sun goes down around 5:30 or 6, so it was very dark at that point. It was about pitch black.
Is there any artificial lighting that you can use out back?
There's a light on the building, but it wasn't on.
And is there any way to turn that light on?
There is a light switch. We were told it's in the store next to us, so we didn't have any control over that light. We weren't able to turn the light on from our part of the building.
So how do you see anything if you can't turn a light on?
Well, you could leave the door open and let some light from inside the building come out.
Is that what you did on January 23rd, 2019?
Yeah, Riley was holding the door open and she was letting light from inside the store come out.
Had you done that before?
Yeah.
And did you ever tell anyone about the exterior light?
Yeah, we mentioned it to store management before, to Lane Kim, was her name, I think.
And did anything get done after you told her about the light being out?
No, if I recall correctly, she said something to the effect of how she knew there was no light outside. That was something that I guess there are always more important, bigger projects to take care of rather than having the light, adjusted to where we could turn it on.
Now, when you went out back to take your smoke break, where exactly did you smoke?
I would always go down the steps, just a little bit farther away from the building.
Why didn't you stay on that platform?
I didn't want any of the cigarette smoke going through the doors back into the store.
Now, this may be a silly question, but how do you get down to the area near the dumpster?
Well, there was just a few stairs down from the platform. You just walk down to the pavement below.
And what do those stairs look like?
They were just old, kind of worn out, concrete steps.
Where was Riley Huntsberger taking her smoke break?
She was standing up on that landing and she was holding the door open.
Mr. Rosa, could you please post Exhibit 4, which has already been admitted into evidence? Mr. Gilmore, can you see this?
I can.
Do you recognize this photo?
Yeah, that's the back door that Riley was holding open on that back landing.
And is this is this how the door looked on the date of the accident?
Yeah, that's pretty much how she had the door open, sticking out from the building like that.
Do you know why she was holding the door that way?
Well, I mean, she was partly holding the door to let some light out, but also, if I recall correctly, it was kind of windy that night. And so she was holding onto the door so it wouldn't get caught by the wind and, slam into the wall or slam shut or, anything like that.
And now at the angle that this door is in, where is that in relation to the stairs?
Well, the stairs are behind the door from this angle. They're back there behind the door.
Now, Mr. Gilmore, do you see that hole on the left-hand side of the photo?
I do.
Would it be fair to say that that's the edge of the stairs?
Yeah, that's what it looks like. Yeah.
Now, between the door and that hole, about how much space do you have there, if you could estimate?
Estimation, maybe 6 inches, maybe a little more, maybe a little less.
Thank you, Mr. Rosa. You can take that down. Now, I want to talk to you a little bit about the moments, excuse me. I want to talk to you a little bit about the moments right before you took your fall. Now, where were you going when you fell?
I had just finished my cigarette and I was walking back up the stairs to go inside the building.
While you were walking up the stairs, did you take any safety precautions?
Yeah, so there was just kind of on one side of the stairs, it was dropping off the pavement below. So I would usually have my hand up, kind of leaning up against the wall of the building to stable myself so I wouldn't, so I'd be steady and I wouldn't fall.
When you got to the top of the stairs, what happened?
Well, because Riley had the door sticking out kind of away from the building across the stairs, I had to step around the door. And in the process of stepping around the doors, whenever my foot slipped and I fell.
How did you land after you fell?
Well, so when I noticed myself falling, I tried to save myself from falling, if you will, and kind of hopped off the ledge and to land on 2 feet instead of just one. But the pavement where I landed was, it was kind of uneven, not a flat surface, I don't think. So all my weight ended up on my right leg, and then I fell to the ground on my butt.
Did you go to the hospital after this fall?
Not that night. I finished my shift and went home, but then I ended up going I think I went to the ER the next morning or sometime the next day.
And were you injured as a result of this fall?
I was. My knee was basically shattered.
Did you tell your supervisor or your boss about this injury?
I did. After Riley helped me up and back into the building, we went and reported it to the manager, to Lane Kim, I think.
Did you tell them how it happened?
I did.
What did the manager tell you after you told them about your accident?
I think that's said something about, we should have fixed those stairs a long time ago. The owners have just different projects that they focused on fixing instead of fixing those stairs. They've just done other things instead.
Thank you. No further questions, Your Honor.
Cross-examination.
Good afternoon, Mr. Gilmore.
Good afternoon.
I want to talk about the area where the accident occurred. It happened on the loading dock.
Yes.
This was in the back of the Chimes department store.
It was.
On the day of your injury, you had no idea who owned you worked in.
I'm sorry, you were cutting out on my end. Can you repeat yourself?
On the day of your injury, you had no idea who owned the building you worked in.
No, I didn't know who owned the property.
You hadn't seen any type of lease agreement for that property.
No, I have not.
And you don't know who was responsible for maintaining that area, do you?
No, I didn't.
Let's discuss the loading area. You were pretty familiar with that area, weren't you?
I was.
And you worked at Chimes for about a decade at the time of the accident.
I did.
You would take at least one smoke break a day during your 10 years at Chime.
Yes,
So you use this area several times a week.
I did.
You'd say that you went to this area as much as 20 times a week.
Sounds about right.
And in all your time working there before this incident, you never had any accidents back there.
No, nothing like that.
Now, during your time at Chimes, the area never really changed much, did it?
I mean, it kind of wore out with time, but nothing major.
Well, you never saw Chimes make any changes to the loading area.
No, I don't think so. It did. No.
And you never asked Chimes to make any changes.
I mean, I think someone complained about the light. I think I might have complained about the light, but
you never asked Chime to make any changes.
no, I guess I didn't.
Now let's talk about the evening of January 23rd, 2019. That night you went out for a smoke break with your coworker, Riley.
Yep,
You went down on the ground level to smoke, as you mentioned on direct examination.
I did.
And as you mentioned on direct examination, you wanted to make sure that no smoke got inside the building.
Correct.
But Riley was smoking too, wasn't she?
She was.
And she was standing on the dock, right?
She was.
As you went down the stairs, you were generally able to see where you were stepping.
Somewhat.
Eventually, you went back up those steps of the dock to get back in the building, right?
Yes.
As you did this, Riley was holding the door for you.
Yes, she was.
But as you went up, Riley had the door open in a way that somewhat blocked your path on the stairs.
Correct.
I'm going to show you exhibits 3 and 6. Mr. Haddon, can you publish those? Which they've already been pre-admitted for the court's reference. Mr. Gilmore, you recognize these.
Yes, I do.
You recognize these because they're photos of the loading dock where you took your smoke break.
Yep.
And exhibit 3 shows the path when the door is halfway open, like it was when you tried to get around it.
Correct.
You didn't wait for her or Riley to open the door all the way, so the door wasn't blocking your path.
Correct.
Now, exhibit 6 accurately shows what the staircase looked like with the door all the way open, as it was when you went up after your accident.
Yeah.
It shows the door as it was when you walked inside after your fall.
Yes.
When the door was fully open, you had no problems getting inside.
I mean, I was having a hard time walking, but because I had just fallen.
Is it your testimony that after the door was fully open, you had problems getting inside?
I mean, because of my knee was hurting and Riley was helping me up.
Mr. Gilmore, this isn't the first time you've testified about this case, is it?
No.
You've actually given a prior a statement about this incident, isn't that right?
Yes.
And when you did so, you swore to tell the truth?
Yes.
Because you understand how important it is to tell the truth when it comes to legal matters.
Yes.
Referring court and counsel to Jordan Gilmore's statement, which can be found on page 74 of the record, specifically lines 15 through 17. And Mr. Gilmore, feel free to read that to yourself as I read it aloud.
I don't.
The question is asked, was the door still open like it was earlier? Answer, no. Now it was completely open and against the wall, and we got inside without a problem. Mr. Gilmore, did I read that correctly?
I don't, were you sharing that on the screen? I don't see anything.
Well, I asked you to, if you're not able to pull it up, I can have my co-counsel.
I'm sorry, I do have my deposition. I don't think I had the same page numbers as you. I didn't have a second.
So it would be page 12 of your deposition. Do you see it? And I can reread that for your reference.
Okay, yeah.
So starting at line 15,
Mhm.
was the door open like it was earlier? And your answer was no. Now it was completely open and against the wall, and we got inside without a problem.
Right.
Did I read that correctly, Mr. Gilmore?
Yes.
No further questions.
Can you redirect, Ms. Jeffries?
No, Your Honor, we just asked that the witness be excused.
Very well. Mr. Gilmore, you can step down. Plan to call your next witness.
Your Honor, we'll be calling by deposition Kelly Danes. May my co-counsel act as Ms. Danes while we go through this deposition?
Yes, she may.
Beginning on page 2, line 6. Good afternoon. Please state your name for the record.
Good afternoon. My name is Kelly Danes.
Moving down to line 12. Tell us about your education.
I have a bachelor's of science in mechanical engineering from the University of Wisconsin-Madison.
Since graduating from college with your mechanical engineering degree, have you gotten any further education?
Sure. I've attended various seminars offered by the National Academy of Forensic Engineers. I took the courses to become a certified person builder from the Scaffold Training Institute, and I took the requisite courses to become certified in ASME B31.3 process piping design from the American Society of Mechanical Engineers. So basically some continuing education and additional certifications.
I noticed that your CV lists you as a PE. What is that?
It stands for professional engineer.
And moving down to page 3, line 8. In which states are you registered as a professional engineer?
I'm currently registered in California, Texas, Wisconsin, Virginia, Louisiana, Idaho, and Washington. And I'm also registered with the National Council of Examiners for Engineering and Surveying.
What do you do professionally?
I'm the president of Danes Engineering, LLC.
And what does your company do?
We provide forensic and investigative engineering consulting and litigation support, specializing in industrial, commercial, and construction engineering, operations, safety, patents, and regulations. So basically, we help to investigate engineering issues in those fields throughout the United States, mostly connected to lawsuits like this one.
Moving down to page 4, line 5. Do you testify mostly for plaintiffs or defendants?
Both, pretty evenly.
And how long have you been in business at Danes Engineering, LLC?
I've been doing that for the past 10 years. Prior to that, I worked for another guy that had his own consulting business, basically doing the same thing, but just doing it for someone else.
And moving down to line 14 on page 4. Over the course of your career, how many incidents have you investigated?
Over 60.
How many times have you been deposed?
About 20.
And how many times have you testified at trial?
Twice prior to this.
Moving down to page 5, line 15. What did you review in coming to your opinions in this case?
I reviewed the deposition of Jordan Gilmore, the deposition of Reese Geller, a number of different regulations from the Occupational Safety and Health Administration, a number of provisions from the International Building Code, and I conducted an inspection of the location of the fall and took pictures of that area.
Your Honor, at this time, we proffer, pursuant to Federal Rule of Evidence 702, we would proffer Kelly Danes as an expert in building safety and regulations.
Any objections?
No, Your Honor.
Very well. Ms. Danes will be accepted as an expert in those areas.
Your Honor, moving to page 6, line 2. Based on your review of those materials, combined with your own supposed expertise in engineering, have you come to any opinions in this case?
Yes, I have.
And moving to page 8, line 16. Okay, what opinions have you come to in this case?
First, the International Building Code and the regulations from the Occupational Safety and Health Administration apply to the stairs and the landing in question, and the facilities in question must be in compliance with those codes and regulations.
And moving down to page 9, line 9. All right, so what portions of the IBC codes and the OSHA regulations did you find important in this case?
First, the general duty clause in the OSHA regulations, which can be found in 29 USCS section 654, and the maintenance provision under section 3401.2 of the IBC.
Why are those significant in this case?
These are general provisions that require an employer and/or the party that is responsible for maintaining a building or structure to keep that building or structure in a safe and well-maintained condition, free from recognized hazards. Here, as you can see from the photographs that I took during my inspection of the stairs, the broken off concrete, the lack of stair railings, the lack of railings on the platform, the door blocking the pathway, and the lack of a light switch to turn on the light above those stairs were all hazards that should have been identified with a simple and effective safety program. But the defendant didn't have such program and never identified or corrected these hazards. So fairly clearly, the defendant violated these requirements under both the IBC and OSHA regulations.
Moving to page 10, line 10. Well, the OSHA regulations apply to the place of employment, right? Are those stairs part of the plaintiff's place of employment, excuse me?
Well, he wasn't out there working at the time that he fell. He was on a smoke break, but he had been instructed to use that area for his smoke breaks. And Chimes uses that area as a loading dock and requires employees to throw trash in the dumpster in that area. So it seems like a place of employment to me.
Objection, Your Honor. Speculation.
Response, Ms. Jeffries?
Yes, Your Honor, this is actually an expert opinion, not speculation. This witness has been proffered as an expert in building safety and regulations. The expert is merely applying those regulations to the Chimes loading area.
Your Honor, brief response.
You may.
Your Honor, this witness has just testified that it seems like this was a place of employment. For an expert testimony to be admissible, it needs to be based on reliable methods, reliable principles. This is purely speculative, and it's not really based on any or referencing any of the guides or standards that this expert relied on in developing this report. And so it is purely speculative, and for that reason should not be included within the record.
Your Honor, may I quickly respond?
No, ma'am. I'm going to overrule the objection. I think that the expert adequately used the facts of the case to support her opinion before stating it.
Yes, Your Honor. Continuing on page 11, line 6. What other portions of the IBC codes and OSHA regulations did you find important in this case?
OSHA 1910.37B1 and IBC 1006.1, which both deal with lighting.
Why are those significant?
Well, 1910.37B requires that lighting must be adequate and appropriate for a building exit like this one. And 1006.1 requires that any means of egress must be illuminated at all times the building is being occupied. In this case, there was a light above those stairs. but there was no switch for that light inside the Chime store. So there was no way for employees to turn that light on when they went outside at night. A switch like that should have been installed long before this incident to make sure that employees could see where they were stepping.
Have you ever seen that light above those stairs turned on at night? And do you know how much light it would have provided?
No, I've never seen that. I just know it wasn't on and there was no switch for it.
What's next?
Next, we move to OSHA 1910.23 D1 and 1910.24 H and IBC 1009.11.
Now, why are those significant?
All of these provisions require that stairways or flights of stairs must have guardrails or railings on any exposed side. Here, there is no guardrail on these stairs on the exposed side, which is obviously dangerous.
Do you know if there was ever a guardrail on those stairs?
Yes, there was, and it was removed at some point.
How do you know that?
Well, first, you can just look at the photographs and see where the guardrail used to be on those stairs. You can see the broken off piping in the concrete. But second, there's a photograph showing a guardrail on those stairs and that landing.
Moving to page 13, line 10. Couldn't a person walking up those stairs have just used the wall to steady themselves and stayed away from the exposed edge of those stairs?
I mean, I suppose that would work, but that's not the question. The bottom line is that those stairs needed guardrails in order to meet code requirements, and they didn't.
All right, anything else?
Let's take a look at OSHA 1910.24H and IBC 1012.1. 1910.24H requires railings on all stair platforms, and 1012.1 requires guardrails on all landings that are located more than 30 inches above the ground. In this case, as you can see from the photographs, I measured the distance from the ground to the top of the landing, and it was 34 inches. So this landing would be subject to both standards. Again, like we discussed earlier, this landing had a guardrail at one point, and it was removed. And depending on exactly where the plaintiff fell, if the stair handrails didn't provide enough protection, then a guardrail around the landing would have given him something to grab onto to keep from falling.
Moving to page 14, line 22. Anything else?
IBC 1005.2 states that doors opening into the path of egress travel shall not reduce the required width to less than 1/2 during the course of the swing, and that when fully open, the door shall not project more than 7 inches into that required width. When the door is open like that, it was at the time of this incident. It obstructs the path up or down the stairs to a 1-foot space between the edge of the door and the edge of the platform or the stairs where the platform fell, where the plaintiff fell, excuse me.
Thank you. This concludes our reading of the Kelly Danes deposition, Your Honor.
Mr. White, do you have anything that you would like to cross-examine this witness on?
Yes, Your Honor. And if it's okay with Your Honor, I'd like to read through a few citations with my co-counsel.
Very well. Mr. Haddon?
Haddon.
Your Honor.
Very well. You can proceed when you're ready.
And for your court's reference, we'll give the record citations for each line that we read from.
Much appreciated.
Starting from page 81 from the record, line 22. Based on what you do for a living, is it fair to assume that you regularly testify in lawsuits?
Yes, no question about it. I testify and I work as an expert on cases on a regular basis. To be honest, preparing expert opinions in lawsuits like this one, testifying in depositions, and testifying at trials are about 99% of what I do at this point.
Page 82, line 21. How did you get involved in this case?
I got a call from the firm representing the plaintiff, Jordan Gilmore. It's a firm I've done work for in the past, so this isn't the first time that I've consulted in one of their cases.
Guess that means they liked what you did in the first, in one of those other cases.
Objection, Your Honor.
Yes, ma'am.
Speculation to the mindset of a third party.
Response?
Your Honor, as an offer of proof, this witness responds. So he actually lets the asker of this question know what his personal experience with the client is, and it goes to show, particularly in this case, bias, which is certainly at issue.
May I be heard?
You may.
I'm not objecting that this is not irrelevant to this case. I'm objecting that this question calls for the speculation of the mindset of the third party, which would be the plaintiff's firm in this case, Your Honor.
Brief response.
Brief response, Mr. White.
This witness is only being asked what his personal perception of his client's experience with him is. And I believe that the jury, as the trier of fact, can easily weigh that evidence, and opposing counsel has every opportunity to argue that this doesn't actually go to show anyone's state of mind, and that's certainly not how we intend to argue it. Just to explain what the expert witness's personal perception of how his clients view his work.
I'm going to overrule the objection at this point in time.
I'll re-ask that question. Guess that means they liked what you did in one of those other cases.
What can I say? I'm good at what I do. I'm good at what I do. Excuse me.
Page 83, line 3. Kelly, I'm showing you what has been marked as Exhibit 15. Do you recognize this?
Yes, it is the invoice for the work that I've done so far on this case, which obviously doesn't include my time today or my time for testifying at trial, if I have to do that.
Page 87, line 4. Do you know or have any opinion on who is responsible for the maintenance and repair of these steps behind the chime store?
No, that's not what I was asked to do. I assume it was Chimes, but that's just a guess. My job was to look at the steps themselves.
Objection, Your Honor.
Yes, ma'am.
Speculation. This witness just stated that he's making a guess, and experts should not be making guesses within this trial, Your Honor.
Mr. White?
Yes, Your Honor. This is the plaintiff's expert witness, who they've just tendered as an expert in safety regulations. It's important that the jury be able to understand the level of seriousness, the level of care, and the level of particularity their expert witness put into the investigation that their client paid him to do.
May I be heard briefly, Your Honor?
You may.
Your Honor, this witness just testified that the answer to the question was, no, that's not what I was asked to do. I assume it was Chimes, but that was just a guess. Your Honor, this is outside of the scope of this witness's expertise, as well as it is speculation, as the witness himself accurately said that he is guessing in this case.
Brief response, Your Honor.
You may.
Obviously, as the counsel for Chimes, we won't be arguing that Chimes was responsible for the maintenance and repair. I think this actually tends to help the plaintiff's case more than ours, but we're happy to redact that part of the excerpt of this response and just stop at, no, that's not what I was asked to do.
I'm going to overrule the objection at this point.
Yes, Your Honor.
Okay. Mm-hmm. So, Your Honor, do we need to reread that, or can we move on to the next line?
You can move on.
Great. Page 88 of the record, line 19. Do the OSHA regulations place any requirements on employees?
Yes, there is a general duty requirement in 29 USCS section 654B, which says that employees also have to comply with the OSHA standards and regulations and basically have to be responsible for their own actions.
Do you have any criticism of the plaintiff's actions in this case?
Again, that's not what I do. I'm just looking at the stairs and the platform from a building and safety perspective. So I don't have any opinion about the decisions the plaintiff made that night.
page 92, line 12. You would agree though that this area was used by Chimes as a loading dock at times.
Yes, at times.
And the guardrail around that loading dock would certainly inhibit Chimes' ability to use it as a loading dock.
Yes, it would make it difficult.
Can you point to any specific regulations or codes related to how or if employees or others must place guardrails around loading docks?
No, I'm not aware of anything like that.
No further questions, Your Honor.
Anything further from the plaintiff?
No, Your Honor. With that, the plaintiff rests.
Very well. Before we move on to the defense case, we're going to take a short 5-minute break. I will tally up your times and we will get those to you before we pick it up. Is there anything we need to take up before we move to the defense case when we get back off the break?
Not from the defense, Your Honor.
All right, then it is 4:01. We're going to take a 5-minute break. We'll come back and pick up the defense case at 4:06.
Thank you, Your Honor.
All right. I have wrapped up the math. Plaintiff, you have 24 minutes, 32 seconds remaining. Defense, you have 34 minutes, 54 seconds remaining. I'm going to check our judges back in and make sure we've got everyone here, and then we will go ahead with the defense case. Will King, are you back? All right, we got you. Ronnie Turner.
Back to it.
Christy Hicks. All right, we got you. And then Cody Hill.
I'm here. Thank you.
All right, are the parties ready to proceed with the defense case?
Yes, Your Honor.
Very well. Mr. White, you can call your first witness when you're ready.
Your Honor, at this time, the defense calls Reese Geller to the stand. Mr. Geller, whenever you're available, just speak so I can see your face pop up on the screen.
Good afternoon.
Good afternoon, Mr. Geller. Please introduce yourself to the jury.
My name is Reese Geller.
I'd like to begin by helping the jury learn a little bit more about you and what you do for a living. So what is it that you do for a living, Mr. Geller?
I am the owner of the Chimes department store.
Where is the Chimes department store located?
It is located right here in Waco, Texas.
How long have you owned Chimes?
I've owned it for 10 years.
And how long have you worked at Chimes?
Quite some time. It's right after I got out of college in 1998. I just started working there, and it's been a dream ever since.
How did you get involved with the company?
It's a family company, and it's been family owned and run for quite some time, stemming all the way back when my grandparents used to own it.
Well, let's talk about the Chimes location. Do you own the building and premises that the store currently uses?
No, I do not.
Well, who owns it?
It's owned by Kermit Realty Group.
What's your relationship with Kermit Realty?
My store and Kermit Realty Group have a lease agreement. And so it's just through that relationship that we are on the premises.
How familiar are you with this lease?
I'm fairly familiar with it. I worked on it with or took part in the negotiations with my father when it came into existence.
Referring court and counsel to exhibits 11 and 12, which have already been pre-admitted. Mr. Haddon, can you publish exhibit 11? Mr. Geller, do you recognize this?
Yes, I do.
What is it?
This is the lease agreement between Kermit Realty Group and Chimes Department Store.
Does this lease provide any details about the area that you lease?
Yes, it does.
And what kind of information does it give about the areas that you lease?
Well, it defines demised premises in section 1.10. And in that section, it explains the area or the part of the premises that we control. And so that's what we pay for. That's the area that we rent from Kermit Realty Group.
Now, you mentioned the lease explains the areas that you rent, but where does it do that?
It says there is an attachment to the lease, and it kind of sets out a map of the area that's owned by Kermit Realty Group, and the crosses where they create hashes. That's the areas that Chimes is in control of.
Now, I'd like to have you look at exhibit 12, which has already been pre-admitted as well. Where on this map did the accident with Mr. Gilmore take place?
The accident with Mr. Gilmore took place in the alleyway, which is directly behind the Chimes department store. So there's an X on the screen, which I've previously marked. And so that's where the accident occurred. That right there, that's where our loading dock is.
Now, you mentioned the loading dock. Is that loading dock that you mentioned a part of the demised premises?
No, it's not.
Did Chimes ever use that area?
We only used it for, as a loading dock just to get, inventory from the loading trucks into the back of the storage unit that we have at the back of the Chimes department store.
Did you use it for other reasons?
No.
Are you sure?
We actually have a dumpster back there, and they will go back there. We have our employees go back there and throw away any trash we have.
And how did the lease classify this loading dock area?
The lease classified this area as a common area.
Did Kermit know that this was designated as a loading area?
Yes, they did. In order for us to make it a loading area, we had to send them an email requesting that the proper procedures were taken so that we could, in fact, make it an effective loading area.
Who does the lease say is responsible for this area?
The lease says that it's the responsibility of Kermit, that the landlord, which in this case is Kermit, is the one that's responsible for the operation, management, and maintenance of those designated common areas.
Well, finally, I want to talk about safety measures. Before January 23rd, 2019, was the loading area safe?
Yeah, absolutely. There was nothing unreasonably dangerous about it.
Did you regularly inspect the loading area for safety issues?
No, not necessarily. We have instructed our employees that if they do see something around the store that looks out of sorts, or something that brings them some concerns, to notify us so that we can maybe take appropriate measures if needed.
Your Honor, we pass the witness.
Cross-examination, Ms. Jeffries?
Yes, Your Honor.
Very well. Proceed when you're ready.
Good afternoon, Mr. Geller.
Good afternoon, ma'am.
Now, you were just describing Chimes a few moments ago, right?
Yes, ma'am.
Now, you describe it as a family business?
I do.
But it's not just a family business, right? It's a corporation.
Yes,
And you're the CEO of that corporation.
I am.
And as CEO, you're the one in charge, right?
Yes, ma'am.
You're the one that makes ultimate decisions.
I would say so, yes.
And safety is important to you, right?
Of course.
Your employee safety is important to you.
Yes, definitely.
Providing a safe workplace is important.
Yes, ma'am.
Following safety regulations is important.
Of course.
And you'd agree that your company should prioritize safety, right?
Yeah, I think that's definitely a priority.
Well, let's talk about how Chimes has prioritized safety over the years. Now, you worked at Chimes when the company moved back in 2005, right?
Yes, I did.
The company needed a bigger space.
Yes, ma'am.
And so the company signed a lease at the strip mall.
It did.
But that building didn't have a loading dock, right?
No, ma'am, it did not.
And you needed a loading dock.
Absolutely.
So your company had the landlord create a loading dock.
We did make that request.
And that loading dock was in the back of the store
Yes.
where the emergency exit doors are.
Yes.
And those there were guardrails outside those doors, right?
Yes, ma'am, previously.
So your company didn't prioritize safety then.
I wouldn't say that. I agree with that.
Well, in fact, you had the landlord remove the only safety precaution that was out there, right?
I mean, I still think that the stairs were usable, so I think that could be a safety precaution themselves if people needed to exit in a hurry.
Well, you requested that the guardrail be removed from the stairs in the landing area, right?
Yes, ma'am.
And that was the only safety precaution that you had out there.
Yes, ma'am.
And this was all to create your loading dock.
Yes.
Now you claim that you don't control the loading dock.
No, ma'am, we do not.
But you do in fact use it.
We do.
In fact, your company uses it exclusively.
Yes, we do.
You don't have a specific recollection of any other company using the back area?
No, but if they needed to, they could have.
And I'm not asking you if they could have. I'm asking you if you have a recollection of them ever using the back area. And you don't, do you?
Not that I can recollect, no.
You don't know of any children using the back area
No,
or of anyone besides your employees using the back area, right?
no.
Now, your company uses that loading dock close to every day.
Yes, ma'am, I'd say that's accurate.
Deliveries are made close to every day, right?
Yes,
And your company requested that employees clean that back area.
just to, just around the dumpster and obviously just to keep it sanitary.
And your company sends employees back there to take smoke breaks, right?
Yes, just to avoid customers running into the smoke out front.
Right. And you put a dumpster directly next to the landing area, right?
If I don't necessarily remember off the top of my head if that's exactly where it is, but I'd say that's probably pretty close.
And Kermit Realty Group didn't put that dumpster there.
No, we did.
And employees take their trash out there every day, right?
They do.
Even though you knew that that could be dangerous.
I mean, I wouldn't say that I would think that that would be dangerous throwing away the trash.
Well, you knew that the steps that they would have to go down weren't in the best condition, right?
I always thought that it was suitable, that there was in suitable conditions.
You thought they were safe enough,
I thought so.
even though you knew that those steps were crumbling.
Again, I just didn't think it was an obvious danger.
Well, in fact, you've had problems with this back area before, right?
There was a previous incident some time ago.
Right. You had an incident similar to this one.
I'd say fairly. I'm trying to a little iffy on the details, but if I remember correctly, it was decently similar.
And you had an employee falling down these exact same stairs, right?
Yes, I believe so.
While taking out the trash.
Yes,
And a manager had to take a report of this incident, right?
they did.
And Mr. Rosa, could you post what has been admitted into evidence as Exhibit 14? Thank you. Mr. Geller, you recognize this report.
I do.
So let's look at that first page of this report. Do you see that last paragraph on the first page?
I do.
Where it details what happened, right?
Yes, ma'am.
We're going to underline some sentences for you. Please read those sentences to the jury.
She told me that there was no switch for that light in our store and that the only switch for that light was in the store next door. So there was nothing she could do about it. She told me just to leave the door open and use the light from inside the building so I could see where I was stepping. I did exactly that, but as I was walking down the steps, I slipped on what I think was loose concrete, and I fell face first onto the ground at the bottom of the steps. There was nothing for me to grab onto, so I couldn't stop my fall.
This employee said that it was dark when she was sent out there, right?
Yes, ma'am.
Said that there was no way to turn that light on.
No, ma'am.
And said that she fell down.
Yes.
Didn't have a guardrail to catch herself on.
No.
So she couldn't stop her fall.
No, she couldn't.
Now let's look at the third page of this report. Now, do you see the area that says for chimes use only, right?
Yes, ma'am.
And that's to be filled out by a supervisor or manager of your company.
Yes.
You see the last question?
Yes, I do.
Please read, this asks about what steps should be taken by your company, right?
Yes.
To prevent such injuries in the future.
Yes.
Please read the answer to that question.
Make sure there's adequate lighting on the loading dock.
Thank you, Mr. Rosa. We can take this exhibit down. Now, you did nothing about this incident, right?
No, ma'am, we didn't.
Right after this incident, you didn't place a light above the stairs?
No, we didn't.
You didn't have a landlord put a switch in for the exterior light?
No.
You didn't install a switch for the exterior light yourself?
No, not till much later.
Now we know that this wasn't the last fall down those stairs, right?
Yes, I think it was a decade Took place in between a little bit over a decade in between the incidents, so it was quite some time. But no, so
Well,
you're
So that's a yes to my question. This wasn't the
Yeah.
last fall down those stairs.
yes, was not the last.
And to be clear, Miss Gilmore or Mr. Gilmore, excuse me, fell down those stairs on January 23rd of 2019, correct?
Yes,
While going to take a smoke break
yes,
in the space that you told your employees to smoke
yes,
at night,
yes, ma'am.
again with no light.
No, ma'am.
And to be clear, nothing prevented you from getting a light source for that back area, correct?
No, there's nothing preventing us.
In fact, there was already a light there.
Yes, there was.
And as you stated earlier, nothing prevented you from getting a switch to control that light, correct?
No.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor.
Very well. You can step down. Defense, call your next witness.
Your Honor, at this time, the defense rests its case in chief.
Okay. Anything further from the plaintiff, or are we ready to move to closing arguments?
Yes, Your Honor. At this time, the plaintiff would like to make a motion outside the presence of the jury.
Very well. We are outside of the presence of the jury.
Pursuant to Federal Rule of Civil Procedure, Rule 50, the plaintiff moves for a judgment as a matter of law. As the court is aware, the defense has a burden to prove their affirmative defense of contributory negligence by a preponderance of the evidence, and they have failed to establish that any reasonable juror would find in their favor. Specifically, they failed to establish that Kermit Realty had any control over the landing area, including the light. And as we just heard, Chimes actually made changes and exclusively used and controlled that back area. Therefore, they have failed to meet their burden, and the plaintiff moves for a judgment as a matter of law.
Response from the defense?
Yes, Your Honor. But we've established a contractual connection between Kermit Realty and also Chimes Department Store. And if we look at the jury charge that the jury will be presented with, Your Honor, one of the ways control can be defined is by a contract. We've already had Mr. Geller testify to this contract as someone who helped negotiate this contract, that the portion of his property that he was leasing, where that was next to the loading area, was not a demised premises. It was a premises under the control of Kermit Realty. And we saw that control, or that level of control, exhibited by Kermit Realty, because they actually required my client Chimes to get permission to move any type of railing or guard railing off of or around that property. And so we have presented enough evidence that a jury of reasonable persons can find that Kermit Realty was in control, and that Kermit Realty did have a responsibility to maintain and keep the area behind the Chimes Department Store safe. And we will also be able to argue that based on the contractual relationship that's already been admitted into evidence.
All right. At this time, I'm going to deny your motion for judgment as a matter of law. And if there is nothing further from the parties, we're going to take a 5-minute recess before closing arguments. I will tally up your time and give you the total that you have remaining at the end of that 5-minute break. And we will go ahead at 4:32.
Thank you, Your Honor.
All right, Ms. Jeffries, you have 15 minutes, 17 seconds remaining. Mr. White, 26 minutes, 15. All right, I'm going to check my judges in one more time. Will, you there? All right, and Ronnie?
Here.
Christy? And Cody?
I'm here.
All right, then. Plaintiff, when you are ready, you may proceed with closing argument.
Thank you, Your Honor. May it please the court. Your Honor, Mr. White, and good evening, members of the jury. Safety first. Now, that was the term that I came up here and said to you at the beginning of this trial. Safety first. But as we have learned here today, when it came to the defendant company, safe enough was good for them. Because for Chimes department store, safety came last. Chimes treated their customers like family, while they treated their employees like trespassers. Jordan Gilmore slipped down the stairs that his employer knew were dangerous. And when he was doing everything the employer asked of him, everything he did was only for the benefit of the employer. Members of the jury, you now have to decide if the defendant should be held responsible for the negligent conduct or if they should just get away with it. In order to make that decision, you now have the testimony of witnesses, the evidence that's been presented, and the law that will be given to you by Judge Strohmeyer. Judge Strohmeyer will soon tell you that the defendant department store has a duty to provide their employees with a safe place to work, to provide them with adequate lighting, protections, and precautions to ensure that each of their employees are safe. And today, we have proven by a greater weight of the evidence, more likely than not, that the defendant breached their duty and was a proximate cause of Mr. Gilmore's injury. And we have proven that to you today because the defendant failed to meet minimum guidelines and allowed safety to fall through the cracks. And today we heard from Jordan Gilmore. He told you that he worked at Chimes for 10 years. And while working there, Mr. Gilmore was a smoker who had to take smoke breaks, and he had to take them in the back of the store, near the emergency exit. The defendant knew that employees smoked, but they were more worried about what their customers would see when walking in the store. The store required that the employees go smoke out by the dumpster, a place full of dangers created and ignored by the defendant. This place was solely designated by Chimes department store, was solely used by the defendant, and was improperly maintained by the defendant. The store put aesthetics above safety instead of putting safety first. Now, we heard today from Mr. Geller, who told us that he was more worried about smoke in the front of the store than his employees' safety. And when he forced his employees to go smoke in that back area, he knew that those stairs were loose and cracked. He knew that that concrete was crumbling. He knew that that back area was not in the best condition. But as he told us today, for him, well, it was safe enough. It was safe enough. Now, the defendant keeps trying to say that they couldn't control that back area. They didn't control the back area. That was Kermit Realty Group's issue to deal with. Yet the defendant told us that he's installed a light switch since this accident. And the defendant told us that nothing prevented him from installing that light switch prior to this accident. The defendant wanted to claim that he didn't control that back area, yet he's the one telling employees to go use it. He's the one placing a dumpster in that area, the one using that back area every single day. Now, none of this excludes the defendant from failing to meet minimum guidelines laid out in the International Building Code and by the Occupational Safety and Health Administration, or OSHA, regulations. Now, we heard today from a professional engineer by deposition, Kelly Danes, that the defendant did not meet any regulations provided by OSHA or the International Building Code. You see, there was a lack of a guardrail that is required on areas like these. There was a lack of lighting there was a lack of lighting, with the only light available coming from the doors at the top of those stairs. And there was a door encroaching on the pathway from the stairs, completely blocking that path, leaving a 1-inch space between the door and falling onto hard concrete. With no railing on the platform and cracked, broken off concrete, minimum lighting, and a door blocking his path, there were safety issues that fell through the cracks. Employers are required to ensure that employees are free from recognized hazards. But the evidence that we heard today showed that the defendant ignored these hazards and let safety fall through the cracks. See, the defendant was aware of all of these hazards. And to be clear, members of the jury, you didn't hear about any other regulations. No one came up here and told you that the defendant actually did comply with any regulations, ordinances, or laws. All that you heard was that they didn't. Members of the jury, how do you dispute that? Members of the jury, the defendant didn't even dispute that they were not in compliance with regulations. And you heard all throughout this trial that plaintiff's counsel claimed that Kermit Realty Group is in control, that they were at fault. But Judge Strohmeyer will tell us that control can be established by a contractual document like a lease, or by actions, by using, controlling, and maintaining that area. Members of the jury, what shows more control? Simply signing a lease 15 years ago? Or using an area every day? Sending your employees out there every day, numerous times a day? Making changes to an area so that way they fit you better? Members of the jury, the evidence today has shown that the only one to blame for what happened today, that day of the accident, is the company that designated a dangerous area as their smoking area without the proper precautions or protections in place. The company that decided to use that area every day, ignoring all of the issues that were there. Now, we understand that Kermit Realty Group may not have been informed of these issues. The members of the jury, make no mistake. Kermit Realty Group has had nothing to do with that building since 2005. Which is why at the end of this trial today, which is why when you go back to deliberate and you look at the jury charge that will ask you to assess liability against Kermit Realty Group or the defendant, Chimes Department Store, we ask that you assess 100% liability against Chimes Department Store. Thank you.
Thank you, Ms. Jeffries. Mr. White, you can proceed when you're ready.
The landlord's property, the landlord's stairway, the landlord's responsibility. My client, Chimes Department Store, is a family-owned business that rented space for its store from Kermit Realty. As the landlord, Kermit signed a lease promising that it would maintain its property in good and safe condition. On January 23rd, 2019, the plaintiff slipped on the landlord's property while walking up the landlord's stairway, and the plaintiff's injury was the landlord's responsibility. Now, nobody deserves to fall down and hurt themselves, especially someone like Jordan Gilmore, a cashier for Chimes. We should all be able to do our jobs without wondering if the place where we do that job is safe. While Jordan Gilmore may deserve justice, it should not be at the expense of an innocent party. For 2 years, Reese Geller and his family have lived under the cloud of this lawsuit. He has sat here this entire trial, but this seat does not belong to him. The landlord, the property owner, Kermit Realty should be the one sitting in that chair. Well, what does it take to build a business, to create something, to carry on the proud tradition of your family? Chimes Department Store isn't some faceless corporation based in a megacity. It's not Macy's or Nordstrom's. It's a family business that serves the families in our community. Reese worked his way up the company and carried his family's tradition by running this business. This was his dream. But it's turned into a nightmare because he is being sued for something someone else failed to do. Mr. Gilmore's fall was unfortunate, but in the eyes of the law, my client's actions weren't a contributing factor. Furthermore, it is the plaintiff's burden to prove by a preponderance of the evidence 3 things. First, that conditions under the control of Chimes Department Store pose an unreasonable risk of harm. Second, that Chimes Department Store knew or should have reasonably known of the danger. And third, that Chimes Department Store failed to exercise ordinary care to protect Jordan Gilmore from that unreasonable risk of harm. Admittedly, preponderance of the evidence isn't a term that folks are familiar with or something that they use in their day-to-day walks of life. To help you better understand, I want to imagine that this standard is a football field, with the plaintiff's case beginning at the goal line of the end zone. In order for their case to be successful, they have to carry their case all the way past the 50-yard line. Not at the 50-yard line, they have to cross over it. They have to do this while dodging all the facts and evidence and testimony that line up against their case. If testimony that was brought forward today or any other facts or evidence tackle their case before it passes that 50-yard line, then their case fails. So let's talk about some of that evidence. The underlying principle of negligence revolves around the responsibility we have to each other and to ourselves. So let's turn our attention to the most important element of negligence in this case, which is duty. The question opposing counsel has failed to correctly answer is who owed the plaintiff a standard of care to operate, manage, and maintain the area behind the loading dock and stairway. To answer that question, you need to look at one place and one place alone, the lease. So let's take a look at that lease. The lease agreement between Chimes and Kermit identifies the loading area as a common area. And you learned today, during the direct of my client, Reese Geller, that his landlord, Kermit, knew about Chimes' loading area. They knew because they turned it into one. On page 10 of this lease, you'll find some very helpful language. Landlord shall be responsible for the good and safe operation and maintenance of the common area, and the landlord shall operate and manage and maintain the common area in a good and safe condition. As we learned today, the lease defines the common area to include the landing dock. A lease is more than just a contract. It's a handshake, a promise to do something. Because this was the landlord's property, they promised to maintain it. because it was the landlord's stairway. They promised to keep it safe because it was the landlord's duty. They are responsible. That's the primary benefit of a lease. You're not just paying for the benefit of utilizing a building, you're paying for the convenience of having a responsible party maintain the premises. It's the right Chimes was entitled to, and Chimes trusted Kermit with that right. We can't allow them to just hop away and avoid responsibility. Now, the lease isn't the only evidence we brought that shows Kermit was responsible for maintaining the loading area. Today, you heard from Mr. Geller. He told you that he wasn't allowed to just remove the railing from the loading area. They had to get permission. When you're responsible for something, when you're in control of something, you don't need to ask for permission. You ask permission when you know something else, when you know someone else gets to decide. Someone else gets to say no. Someone else is in control. Now, opposing counsel has the responsibility, the burden of proving that Chimes is responsible for the loading area. The facts I've just discussed prove otherwise. Besides their own personal opinion, the plaintiff has no evidence that Chimes was responsible for this area. Now, during your jury deliberations, you're going to be allowed to review some of the statements from the plaintiff's expert witness, Kelly Danes. Now, the plaintiff paid for her opinion, but made sure that that opinion wasn't comprehensive. When asked if she knows or even has an opinion about who was responsible for the maintenance and repair of the steps Mr. Gilmore fell from, Kelly Danes' response was, "No, that's not what I was asked to do." There's a reason she wasn't asked to do this, because the answer to that question doesn't support the plaintiff's case. When Kelly Danes was asked if she had any criticism of the plaintiff at all, again, she replied, "That's not what I do." Well, their expert admitted they don't go around criticizing their paying customers. You see, Kelly Danes isn't much of an expert at all. She's a litigator. You see, a litigator fits facts into a narrative that benefits their clients. An expert vets all of the facts regardless of where it leads them. Career litigators like Kelly Danes help sue people for a living, and they don't get paid unless they say something that's helpful to their client. But her inability to conduct an honest and thorough investigation doesn't help Jordan Gilmore. It hurts him. It doesn't resolve injustice, it perpetuates it. We're still left with this essential question this case is rooted in. Where is the negligence? They have to prove it. They have to prove negligence. A tidbit, a little bit, moderate, adequate, kind of a lot. That's still not more likely than not. They've got to prove it. They've got to explain why Chimes is sitting as a defendant in a negligence lawsuit. They've got to answer the questions their expert wouldn't. Chimes wasn't responsible for maintaining the loading area, and no one proved by a preponderance of the evidence that they were. Now, maybe there's something Chimes can do to help Ms. Gilmore, and they're more than willing to have that conversation after trial. But it's important for my client to defend themselves in court because this accusation, despite how sincere it may be, is false. Chimes has a duty to defend their reputation, not out of pride, but out of necessity. The jury deserves answers. Mr. Gilmore deserves closure, and Chimes, they deserve a just verdict. Due to a biased expert witness and investigation that didn't even attempt to answer the most important questions, and the absence of Kermit Realty, who should be sitting in my client's place, none of us got any of those things. For that reason, I'm asking you to return a verdict of not liable, because the loading area is the landlord's property. Ms. Gilmore fell on the landlord's stairway, and what happened to her is the landlord's responsibility.
Rebuttal, Your Honor.
Go ahead.
What does it take to build a business? That was a question the defense counsel posed to us. Members of the jury, what it takes to build a business is following safety regulations, ensuring that your employees are safe, and maintaining the work areas that you require your employees to be in. What does it take to build a business? Building a safe business. Now, we heard a lot today about the lease that Kermit Realty and Chimes Department Store signed. Members of the jury, the lease is not law in this courtroom. The lease is not a safety regulation that the defendant must follow. Now, what the defense counsel said that the lease was a promise between Kermit Realty and Chimes Department Store. But what he failed to recognize was the promise that Chimes Department Store made to Jordan Gilmore, a promise to keep him safe at work, a promise that he would go home every night uninjured, a promise that the areas that he was told to go into would be well maintained, a promise that was broken. And this broken promise resulted in this injury here today. Find the defendant 100% liable. Thank you.
All right, with that, court is in recess. Well done, Mr. White, Ms. Jeffries, both of you. What I'm going to ask to happen now is for all of my judges to finish filling out your ballots and submit those. Once you have submitted your ballot, you are welcome to turn on your camera and give some feedback to these two competitors that they can take on with them. And then I will go and talk to our team here and make sure that all of our ballots are submitted. Please do stay in the room until I have come back and released you, so that if there is something we need to address on your ballot, we can get a hold of you quickly and get that taken care of. All right, I'm going to open the floor for comments. So judges, if y'all have a positive thing, something to work on for each of the competitors, y'all are welcome to do that. We're going to keep it pretty quick because I know the teams want to eat and they want to make adjustments for tomorrow. I know y'all aren't shy. Somebody go ahead.
I think Mr. Turner should start.
Sure, I'll start. First of all, guys, congratulations for being here. Both of you guys did just an excellent job. It really made my job as a judge very hard. So I just wanted to congratulate you first and foremost. I know it's not easy. It's a different way of trying the case of having a mock trial tournament, and you both dealt with it very well. Okay, very well. So I just want to say that first and foremost. I'll just give each of you one thing that I think you could work on. Ms. Jeffries, I think you did an excellent job. Don't rely so much on your notes. I can see sometimes when you're looking at the notes, which is probably behind your camera, I can see you looking around to look at it, but you really don't need it, to be honest with you. And during your rebuttal, I thought you did an excellent job, and that shows that you really don't need those notes so much. So rely upon your skill and your confidence, and not so much on what's behind the screen. Mr. White, I thought you did an excellent job. My one thing I would advise you to do moving on to the next round is just being a little bit more confident in your objections and your responses. You have the right answer most of the time. You have good arguments. You just need to present it in a confident way, like you do your openings, like you do your closings. Present it in a confident way. It is a part of presentation, literally. And anybody who tries case will tell you, you object to for the judge and to the judge, but you're also objecting for the jury. Okay, so it is definitely a part of the presentation. Just be more confident, have confidence in that what you're saying is correct. But again, both of you guys did a good job, a great job, really. And thank you for being a part of this competition. It was enjoyable. I always enjoy it.
All right, Will, if you volunteer people, I think you get next.
I guess I'll follow up then. I agree with everything that Ronnie said. I know that y'all are under very tight time constraints, and it's very difficult to, figure out all the moving parts of the case on the fly like that. I'll just give some just general comments. First thing is, don't overreach too much when you're kind of making arguments to the jury, because remember, you're talking to regular people. So, for example, I'm a recovering smoker myself. I don't consider it to be part of my job to, go out by the dumpster to smoke. So you might want to just try to avoid things like that when it may not fit with common sense. Defense counsel, I actually had a case just like this last year involving a tenant who got sued for premises liability claim. And believe you me, I hammered the heck out of the lease. And who actually owes the duty. But I did that on summary judgment. If you're talking to the jury about who bears responsibility, remember what kinds of facts will actually appeal to the jury, the practical things about the case. But otherwise, good job to you both. Good luck.
I can chime in next. Again, I think you guys did a wonderful job. You both have great presence, which is just a huge part of the presentation of your case. You were well spoken throughout. I could hear you. That's a big part of it, and more than you may realize, but you'll both have great courtroom presence. So good job. I'll just give a couple other comments. I agree with my other judges on what they've said so far. Miss Jeffries, just two comments. One, you talk about safety a lot, which I think is a really great thing. Safety as a general rule is great, but if you can break that down into smaller safety rules to really ping them on things that no one can disagree with, those are always really helpful. And then with your client, I think that if you talked a little bit more about the incident and how that affected him. I don't know if there's a damages or if you guys are there yet. If you're just doing liability, I understand that. Looks like you're nodding. So I've done this. I see it evolve. And I also know you're working against time constraints, but even if it's not a part of the liability question, you still you want your jurors to relate to him. You want them to understand why he's bringing the suit, even if it's not what your actual injuries were. So I think that would have been helpful. Mr. White, I thought you did a really great job. You can tell when you are passionately arguing about something. Like my fellow judge said, you know the answer and be confident in it, because you could really tell when you were confident in what you were saying and how you were saying it. My comment for you is, I think that you did a good job hammering the lease and whose responsibility it was. What I think would have been helpful for you is, you want to make them find for you. And part of that is showing that you're a safe employer in other ways. And so really honing in on, we care about our employees. We strive hard to do it so that when you point to the lease, when you point the finger to someone else, that's more just giving the jurors a path to what you want them to do, because they've already decided that they like you. You're a good employer. You provide safety, things like that are separate and apart from, we have control over this premise versus we don't, because that's very technical. Develop that testimony a little bit more just to make them really want to find for you. But both you guys did phenomenal jobs. Well done.
All right, Cody.
Yes, so I'll echo what everybody said. Congratulations to both of you, and you did very well. And I've tried to, I agree with pretty much what everybody who said. I took a few notes, and we'll try to make some things a little bit different, so you're not hearing the same thing from every one of us. Miss Jeffries, you had an objection to keep something out from your own expert, and the basis of your objection was that your own expert was speculating. I believe my colleague Ronnie here made a comment about the purpose of making objections and your presentation. That objection, in all likelihood, if you're in a real courtroom, probably is going to be made in front of a jury. That's not a 403 objection. You're probably going to be making that argument right in front of the jury. Maybe, depending on your judge, you're in a bench conference and it's not. But think about that conceptually, what you just did. You just completely undermined your own expert, and you understood why, but put the pieces together and think about what you're doing, right? Mr. White, I would have made a whole story in front of the jury about that, and you have the substantive point, but what my colleague told you there, you're making that argument to the judge, but you're making sure it's heard by the jury and understood. So just think of kind of some substantive points that come in. How does what I'm saying, what I'm doing, fit into this narrative that I'm telling, that I'm presenting? That's kind of a one-off example that I had. I was also going to note, Miss Jeffries, you were very good when you were talking to us. Your cross-exam of the defense witness was very good. It was smooth, it was quick, it made the right points, and you were looking at us and making those points. In your closing, we could see, this is one of the problems with Zoom. Better than, you wouldn't have your notes probably in front of a jury in reality, but we get this zoomed in picture of you and we can see your eyes. And so you were in your closing, somebody else commented on it too. You would, just to get yourself back to it, but we could tell you were reading your notes from above the camera. And then in your rebuttal, you got up, or in other pieces of your closing, you looked straight into the camera and we could see when you were talking to us, and it was really effective. Trust yourself. I know it's really hard, especially in a 24-hour turnaround, but you've read it, conceptually where you're at. Notes help to keep you organized, but speak to us. That's what is most effective. Mr. White, I thought you were very good all across the board. I think you present yourself well. You're persuasive. I thought your closing argument was really good. You really argued points that in a really good way. And in a trial like this, everything, you've got a map and you're pulling different pieces and you're establishing different things and they come together in the closing, and you did that well. But you're empty chairing this plaintiff, and this is somewhat duplicative of what folks have told you. You got to give us a reason to like your client. Christy just talked about presenting, when you put your client on direct, go through the things that your client has done and why safety is important to them. Go through those points you made in closing that you argued with the witness about why it is that you have to outsource this or that or the other. But, if you're going to point the finger at someone else who's responsible, first, you kind of need to establish how we're responsible, how we do what we can, or how it makes sense that we can trust someone else and to be responsible for something. So, if you're pointing the chair, or pointing the finger to empty chair this case, and you've got a responsibility to kind of prove it. Think of it as a plaintiff at that point. You're now making a case to prosecute this third party. And to do that, you still want to, present why, from a practical standpoint. Someone else said, think of those practical facts. I think that was Will talked about, this was my argument on summary judgment, but I got to kind of reassess how I present that to get folks to really understand why that makes sense. And then the other thing that I would say for you, listen to your witness. Your whole point was, we don't, from a legal standpoint, we don't own this property. And you got your witness to say that. And of course, I know you don't get much time to work with your witnesses and coach them up and those things, but he slipped. As you were reading through the lease, he says, yeah, through that lease relationship, that's how we owned the property. And you moved on. It was easy. But the reason you moved on, this is my opinion, is you weren't really closely listening. You want to probably clarify at that point, because you're making a pretty technical legal argument about ownership. And if I'm a juror that only listens to every third word, and I happened to tune in when I heard your witness say, yeah, we own this because of through this relationship, it's something you want to clarify. So just always be listening. And if you're having that communication and not thinking, what's my next point in my outline and how do I get to it? You'll hear that, you'll clarify it, and things will go a little bit smoother. But those would be kind of my high level points. You both did very well. I was very impressed. So congratulations for being here, and thanks for putting a good show on for us.
Absolutely. I thought both of y'all did really well. Tyler, one comment from me on cross-examination. You do a really great job leading your witness. You also have a tendency when you're transitioning from point to point, and sometimes when you're nervous about what your witness is going to say, to lead on direct. So just be aware of that, because if you had gotten an objection for that, I would have sustained it. But otherwise, I thought you did a really great job making your points concisely and then moving on. Defense, you had a really great line that I liked in your closing argument. When you're responsible, there's no need to ask permission. I thought that was really great. I think you should keep it there because it sums up your argument concisely. But then you also backslid shortly thereafter and said, maybe there's something we can do to help the plaintiff. There's no need for that. You can make your argument, and you did that really well in your opening, saying nobody should fall at work and being sympathetic to the plaintiff. But there's not really a need to go back and say, look, maybe we can do something, because then your judge and your jury are just going to go, well, why haven't they already done this? Why are we here today? Why is wasting all this time? I have gotten the high sign, so we have all of your ballots. My judges, y'all are good. Thank y'all for being here today. To both of y'all, best of luck with the rest of the tournament.
Yeah, thank everyone for volunteering and for your time. And thank you, opposing counsel. It was a really fun.
Thank you guys. And Josh, it was fun. I knew it would be, and I'm glad we got to do this.
Thanks, y'all. Best of luck.
Bye all.
Thank you all for your comments as well.